Okay. Welcome committee members, liaisons, and members of the public to the Council on Access and Fairness Committee meeting. Thank you for joining us. We are using Zoom with the goal to foster a more inclusive environment and effective meeting. If you would like to comment during the meeting, please type "I have a comment" or "I have a question" in the chat feature, and a message will be sent to the host. Alternatively, you can also use the raise hand feature. In efforts of transparency for all of those joining this public meeting, whether by phone or Zoom, we request that you refrain from having side conversations on chat about the content of the meeting. Again, the chat feature is utilized simply as a tool for you to virtually indicate that you would like to speak in order to help the chair facilitate the discussion. A friendly reminder that going forward, all committee meetings will be recorded and posted to the State Bar website. And also another reminder that this is a video conference, and to please just be aware of your surroundings behind you. If you are using your phone to dial into this meeting, please be sure that your computer's microphone is on mute to avoid audio feedback issues. And while joining audio via computer is highly recommended, if an individual loses audio, you can call in separately using the Zoom conference number.
All right, thank you, Vicki. Good morning, everyone. My name is Ryan Harrison. I'm the Vice Chair of the Council on Access and Fairness. I will be conducting today's meeting. Judge Esther, our current chair, is unavailable for today. And I would like to go ahead and ask our program supervisor, Elizabeth Hom, to take the role to establish a quorum for us.
Great. Judge Esther Kim, Ryan Harrison.
Here.
Heather Anderson. Novella Coleman.
Here.
Sarah Good.
Here.
Michael Rhodes.
Here.
Block Richards.
He's here. I just promoted him as panelist.
Okay.
Here.
Thank you. Kristen Rosie.
Here.
Stephanie Chu Santoro. Okay. Sal Torres.
Present.
And then our Board of Trustees and Committee Liaisons, Pat Lee.
Here.
Kenneth Wang. Judge Erica Yu.
Here, thank you.
Sonia Dellin.
Here.
Jose Cisneros.
Here.
And then we have several State Bar staff with us today. Brady Duer.
Here.
Andrea Fatanides.
Here.
Erica Carroll.
Here.
Okay. So we do have a quorum.
Thank you, Elizabeth. Our next on the agenda item is the call for public comment. This is a chance for members of the public to speak on any item on the agenda. Please note that the chair reserves the right to limit the duration of the public comment. Do we have anyone who would like to make public comment?
Can I introduce myself?
Absolutely.
Hi, I'm Mark Toney, and I'm one of the people who's recently appointed to the Board of Trustees for the State Bar. I just wanted to say hello. I'm very interested in your work here for the council, and I am sitting in just as part of my orientation to learn more about the activities of the bar, particularly when it comes to increasing diversity, equity, and inclusion.
Thank you, Mr. Toney. Glad to have you with us and welcome aboard. Is there anyone else who would like to make public comment? Seeing none, I will move along the agenda to the chair's report. Again, welcome all. I would like to welcome you all on behalf of Judge Esther, who's unavailable for today. I also would like to welcome our new members of COAF. We have 5, and those new members are Novella Coleman, Sarah Good, Michael Rhodes, Shalak Richards, Stephanie Chu Santoro. Welcome. Also, I'd like to welcome our liaisons, Kenneth Wang from the California Lawyers Association, Patricia Lee from California Law, and Judge Erica Yu from the Judicial Council. and also our Board of Trustee members who are also present with us today. Thank you guys. Now, excuse me. I want to note that we do have an informal brown bag lunch today so that the new members and the current members can chat informally and get to know each other. And so there will be logistical information provided to you on how we could facilitate that brown bag lunch. And if anyone has any specific questions, Elizabeth can address them. All right, so Elizabeth.
Just for the brown bag lunch, I will be sending, now that most of the people have joined, I didn't want to send two links to confuse people, so I will send out the link for the lunch brown bags shortly.
Thank you, Elizabeth. All right, moving along to the consent agenda. I would like to request a motion, and if Elizabeth could please call the roll after someone moves to adopt the items in the consent agenda.
So moved.
We actually need to do a roll call vote. So we have, who moved? I'm sorry, Sal?
I did, yes.
Okay.
And I think we need a second as well.
I second.
Oh, or someone else can.
I have Shalak seconding, thank you. And I'll do the roll call now. Judge Esther? Ryan Harrison?
Yes.
Heather Anderson? Novella Coleman?
Yes.
Sarah Good?
Yes.
Michael Rhodes?
Yes.
Shalak Richards?
Yes.
Kristen Rosie?
Yes.
Stephanie Chu Santoro? Sal Torres?
Yes.
Okay, motion carries.
Thank you, Elizabeth. Next on the agenda item is the state bar reports. I would like to welcome our new director of the Office of Access and Inclusion, Andrea Fitanides. Please let me know if I mispronounced your name. And I'll go ahead and turn it over to you and allow you to update us on what's going on with the state bar.
Well, thank you, Ryan. And actually, you said it perfectly, which is a rare moment. So thank you for that as well. Well, it's so nice to be here. Welcome, everyone, including Justice, our special guest star this morning. So as Ryan mentioned, I am newly in this role. I know I had the chance to meet several of you during the orientation earlier this week, but very excited to be with the Office of Access and Inclusion. For those of you who I didn't get a chance to meet on Monday's orientation, I come here most recently from a pro bono counsel role at two large law firms. I was at Morgan Lewis and Covington and Burling. And prior to that, I was a legal aid attorney at Justice and Diversity Center with the Bar Association of San Francisco. So very excited to be working on the access to justice and diversity inclusion issues in the office and working with this wonderful commission and our staff. Just a few very quick reports. As you likely saw, the Supreme Court and the State Bar solicited applications for the Blue Ribbon Commission on the future of the California bar exam. The commission is going to be comprised of approximately 17 members, representing various stakeholders. And the goal is to have 2 members of COAF on the commission, which I think is great news to have the perspective of this committee as we look to making the bar exam, improving it and making it, looking at the recommendations of the California Attorney Practice Analysis Working Group and ensuring that we move forward with that. So thank you to those that applied. And I believe that the Supreme Court is going to be making appointments to that Blue Ribbon Commission soon. My other update is just a staffing update from our office. So we are in the process of filling some vacancies. We're currently in the process of hiring for 2 new senior financial analysts. We believe that bringing 2 new financial analysts on within the Office of Access and Inclusion will strengthen the work that we do on our bank compliance and IOLTA program, which in turn strengthens our ability to fund the important work of legal aid across the state. And we are also very excited to welcome 2 new senior program analysts just this past Monday. And they're actually here on this call. So I'm going to allow Chris and Judy to introduce themselves, please.
Hey everyone, it's nice to be meeting all of you. Some of you I met briefly earlier in the week. I'm Judy McManigal, and I come to the State Bar from a background in nonprofit administration and immigration law. And I'm very happy to be here doing this important work.
Good morning. My name is Chris McConkey. It's a privilege and very exciting to be here. I was most recently at One Justice, which is one of the State Bar of California's funded support centers for legal services orgs in the state, where I was the director of finance. Before that, I was a legal aid attorney.
Great. Yeah, very excited to have them both on board. Welcome again. And we think that their skill sets will greatly complement the work of the office. Just as a reminder, all of our staff do have diverse portfolios across the access and inclusion work. So, you know, they'll be working with Chris and Judy as well as Elizabeth and our other staff members as we take on these diverse portfolios within what everyone has on their plate. So with that, again, thank you for the welcome and happy to be on board.
Thank you, Andrea. All right, moving along to the next item on the agenda is an update on the attorney discipline system. And that update is going to be given by Dag McLeod, Director of Office of Research and Institutional Accountability, and Lisa Chavez. However, before we begin with that update, I would like to welcome our Board of Trustees President, Sean Salig, who is just came into attendance. And go ahead, President Salig, and provide some remarks.
Hello, good morning. Thank you for having me this morning. So I'm very glad to join you today. I'm actually the chair of the Board of Trustees. I don't get to be called president anymore. It does sound a little fancier, so I'm glad for the promotion. And I'm especially glad to join this group. I am the, believe it or not, only the second openly LGBT chair or president of the State Bar of California in nearly 90 years of existence. So I'm very proud to join this group in particular in that capacity. I want to congratulate Judge Kim and you, Ryan Harrison, on your appointment as chair and vice chair, and give a special welcome to the new members of the committee. We're really looking forward at the board to seeing your work in the upcoming year. I had the opportunity last year to work with Judge Harbin Forte on a particular COAF matter, and she suggested that I join one of your meetings, and I said I would, and I'm very glad to do that. I want to actually talk for a moment about the attorney discipline issues, because the board has been very invested in some initiatives around the attorney discipline system, and I thought I'd just give some remarks on those, and the staff can supplement after and correct me, I'm sure, if I make a mistake. By way of preface, these initiatives reflect the board's increased focus on the State Bar's regulatory mission since the separation of the sections, which is now the California Lawyers Association, as you know. And as you probably already know as well, a couple of years ago, the bar on its own initiative commissioned a study of the discipline system to search for inappropriate disparities. And unfortunately, that study did find a disparity in the imposition of more severe levels of discipline on Black male attorneys. Since that time, the board and bar staff had been working on investigating and resolving that disparity. As one example, the study that was presented to the board indicated that the disparity was tied to an increased number of complaints against Black male attorneys. And one of the interim reforms the board has already put in place is to eliminate, in most cases, consideration by OCTC, the prosecution office, of complaints against an attorney that are more than 5 years old and did not result in investigation. And so that was an effort to avoid what I call the snowball effect that appears to be part of this disparity. Although that sounds like a simple reform, it actually was fairly complicated because of the size of our discipline system and the number of California attorneys. So it has been a very significant project for the staff to implement. They have done that very diligently by implementing certain programming changes in the system, and that has resulted in the archiving of over 500,000 complaints. So that alone is a very significant change. But the board has not stopped there and has chartered an ad hoc commission to study the discipline system overall for its, in terms of efficiency, fairness, and effectiveness. In partnership with COAF, we have included as a guideline, 2 slots for COAF members to serve on this commission, and the application process is going to open very soon. So I encourage those of you who might be interested in serving on this commission to apply. This commission is really notable, and I'm very proud that the board has elected to proceed with this initiative. Although the State Bar is obviously always continually looking at its policies and practices and making changes, and has been especially active in that regard in the last 5 to 6 years, this kind of comprehensive examination of the discipline system with systematic input from outsiders has not been undertaken for about 30 years since the reforms that led to the creation of the State Bar Court. So this is a very important juncture in the development of our discipline system and its service to the citizens of California. Just a few, I'm not going to even attempt to identify all the topics, but just to finish this up, some of the topics that I expect the commission will study and consider are to consider work that has already been underway to examine recidivism of attorney misconduct and how best to prevent it. So that includes things like whether measures that could be seen as more punitive are effective, or whether there should be increased consideration of efforts to rehabilitate attorneys who have had problems and that has led them into misconduct, so that we can restore them to a productive path in serving the public. We're also going to, I expect this commission will also look at proactive approaches to avoid misconduct from happening in the first place. That's something that the board's governance and the public interest task force has already looked at on a preliminary basis. And that has already resulted in some reforms being implemented. And the final thing, and this is very important and something that to my knowledge has not been looked at with external input for quite some time, is an analysis of enforcement priorities and charging practices, which is of course central to the operation of a discipline system that is roughly modeled on criminal justice, although it's different. So in conclusion, I just want to thank you all. I want to wish you the best of luck for a very successful year. And thank you for your service on COAF.
Thank you, Chair Salik, and thank you for inviting us to participate on this commission. I know that we're going to be doing good work on this commission, and that's really great news. All right, so next up we have the Chief of Mission Advancement and Accountability, Dag McLeod, and Director of Office of Research and Institutional Accountability, Lisa Chavez. They will provide an update for us on the attorney discipline system.
Thank you. I'm Dag McLeod. I'm the Chief of Mission Advancement and Accountability at the State Bar. The Office of Research and Institutional Accountability is part of my my portfolio. Lisa Chavez, the Director of the Office of Research and Institutional Accountability, is here with us. I'm here to discuss the work that Sean alluded to regarding disproportionate discipline. And I'm going to give a quick overview, and then Lisa will talk in some more depth about some of the work that has been done to address the issue. By way of background, Chair Saleg mentioned a study that was conducted related to disproportionate discipline found in the attorney discipline system. The motivation behind that study related to concerns that have been raised in the past from attorneys of color, as well as from solo practitioners, about disproportionate discipline, about a sense that the State Bar singled them out and was unfairly seeking to discipline them in a manner that was inconsistent with the way that the State Bar acted more generally against attorneys in large firms or against white attorneys. And our former executive, having heard these concerns, decided to go ahead and conduct a study and really dig into the matter to determine whether there was evidence beyond the anecdotal that would point to disproportionate discipline in the attorney discipline system. That study was conducted by a professor at UC Irvine. We sometimes affectionately refer to the study as the Farkas Report. It was Professor George Farkas who conducted this study, and it was a pretty massive quantitative analysis of attorney discipline, looking back at about 30 years of attorney discipline, taking all of the attorneys who were admitted between about 1990 up through about 2009, and then following and cutting off the sample of attorneys, the date of admission at about 2009, so that there was about 10 years of follow-up, at least 10 years of follow-up from date of admission for all of the attorneys in the sample, to then look at discipline imposed upon attorneys from that initial period of time when the attorneys were admitted up into 2019 at the time. We were looking at the data through it might have been 2018 because the study was completed in 2019. So a very large quantitative study to look at the factors that contributed to discipline, and in particular to pull out their data on race and ethnicity to determine whether or not there was a disproportionate impact upon attorneys of color. The top line findings is that there are, and if you look at, in particular, you simply look at the proportion of attorneys in the general population of licensed attorneys by race and ethnicity, and you look at the proportion of attorneys who are disciplined, and in particular, the study focused on probation and disbarment, the two most severe forms of discipline. The study found that in particular, African-American male attorneys were more likely to be placed on probation, and they were more likely to be disbarred. So that was the top line finding. Now, this type of quantitative analysis typically goes into then what's called a multiple regression analysis, which I expect that most of you are familiar with, which involves taking all different types of information that might be used as control variables to evaluate the extent to which other factors that are correlated with race and ethnicity may be responsible for the impacts that we're seeing at the top level. The multiple regression analysis found that if you run the equation and you look at the significance of race and ethnicity controlling for other factors, so controlling for things like prior complaints, whether an attorney had a lot of prior complaints, controlling for whether the attorney was represented by counsel when they were investigated for misconduct, controlling for the type of complaint against the attorney. When all of those factors were brought into the multiple regression equation, in fact, the significance of race and ethnicity disappeared entirely. There was no statistically significant impact of race and ethnicity based on the sort of statistical analysis. Because we're not in an academic world here, though, because we're in the world of practice and policy, and because at the end of the day, these things that are correlated with race and ethnicity, such as representation by counsel or a larger number of complaints, have real world impacts. We didn't look at the regression analysis and say, okay, well, we're done here. There's nothing more to see, move on. In fact, we took the findings from that report and determined that we needed to look at those correlates of race, ethnicity, and figure out what could be done about them. So following the presentation on the statistical analysis by Dr. Farkas, it was November of 2019, we identified a professor of law who also works in areas of implicit bias and works in areas of organizational development, and asked him to come and take a look at the discipline system and provide some preliminary recommendations. This is Professor Christopher Robertson, who was at the University of Arizona at the time. He's since moved to Boston University, and we've continued working with Professor Robertson. Professor Robertson provided some preliminary recommendations related to a number of different factors at the January planning meeting of the Board of Trustees, and the Board of Trustees directed Professor Robertson to continue his work and to dig in and provide better informed recommendations. It was really a pretty quick evaluation that he did over the course of December, January of 2019, 2020. And so Professor Robertson then, following his presentation at the January planning meeting, spent the next 4 or 5 months digging in even more deeply into the discipline system and providing recommendations to the Board of Trustees at their July meeting. I asked Elizabeth Hom to provide you with, I don't know if she had the opportunity to send out, she's nodding.
Yes.
So to send out the reports, the various reports that provide the foundation for this work. So the Farkas report from 2019, the PowerPoint that Professor Robertson presented in January of 2020, and then the July recommendations following up on that report, as well as the September status report updating the board on implementation, and I think also the November agenda item updating the board on the recommendation. So there's a lot of work that's been done on this, but I think to cut to the chase, I will simply say that echoing what Trustee Chair Saleg said, there are a number of significant opportunities for improvement of the system that Professor Robertson identified, and a number of actions that have been taken to move on these. I will leave it to Lisa to talk in more detail about those, but just to provide some headings for what she's going to discuss. I think that she's going to go into some more depth on this issue of the masking of and archiving of complaints that are more than 5 years old that resulted in no discipline. We've done significant work on the matter of reportable action bank matters, which are an area where we see disproportionate reporting coming in against African American men, and the treatment of these to provide a more proactive risk-based approach, which looks to provide resources to attorneys when they first come to the attention of the Chief Trial Counsel's office as a result of client trust accounting issues. And then the final issue relates to representation. Professor Farkas's study found that African American male attorneys were about twice as likely not to be represented by counsel than their white counterparts. And so we've been working on providing information and strong language to encourage representation by attorneys who are facing disciplinary charges by the Chief Trial Counsel's office. So with that, before I turn it over to Lisa, if there are any questions about the background or sort of the big picture, I'd be happy to answer those. All right, well, seeing none, and let me just double check the chat. Nothing in chat. So I'm gonna mute my microphone and turn it over to Lisa Chavez.
Hi, good morning, everyone. My name is Lisa Chavez. I'm the director of ARIA, and I'm pleased to share with you the work that's been completed to date on the projects that Dag described. This work has been a labor of love between OCTC and my office, and I'm really pleased to share the work that has been completed to date with you. And I will also conclude my presentation with giving a few more details about the ad hoc commission on the discipline system. Okay, so let me share my screen. Let's see, here we go. Okay. So like I said, I'm going to just give you an update on the changes that have meant to address disparities in the discipline system, as well as I'll give you more details on the ad hoc commission. So first I'll discuss the project regarding archiving 5 years of close complaints. So what motivated this project was that Professor Farkas is finding that attorney discipline is correlated with the number of prior investigations. And in particular, he found that Black male attorneys received a disproportionate number of complaints. And so the recommendation was to prevent staff from viewing closed complaints, particularly those had been closed without discipline, to prevent staff, investigative staff, from investigating any of the complaints whenever they're investigating a new complaint. And so I'm pleased to share that we've archived approximately 400 cases from view from staff. And right now we're planning out how we're going to moving forward as cases meet the 5-year threshold of having been closed without discipline. Those two would be shielded from view. So another project, as Dag mentioned, has to do with reportable action bank matters. What motivated this project was that the finding that among attorneys with large numbers of complaints against them, Black male attorneys were more likely to have a large number of reportable action bank cases. And these are the types of cases where there's an overdraft in their client trust accounts. So the recommendation was to first explore the impact of lowering the non-sufficient funds threshold that would trigger an investigation, and then also exploring proactive preventative measures. Our analysis showed that low RA bank matters actually did predict discipline. And so the conclusion of that analysis was that public protection required that the threshold not change. So that led to us directing our attention towards these preventative measures. And we engaged in 2 big projects. First, OCTC enhanced and expanded access to resources to attorneys. So just for big picture information, when OCTC receives a complaint or receives a notice of an RA bank matter, they deal with it in multiple ways. First and foremost, contacting attorneys through a series of different letters. Those are on the right. And in the past, they've given them resources to deal with client trust accounting issues only in the letter that was called a resource letter. And the big change OCTC made to move forward was to take all those resources and apply them to all of the letters that are listed on the right. The biggest letter that they tend to send is a closing letter, which is just, we investigated this, we're going to close this case. All resources are in all those letters now, which will reach over 800 attorneys annually. And those resources include information like, here's information on learning more about client trust accounting school, different resources the State Bar offers, links to online materials. They enhanced the resource descriptions. They included new warning language, and they also gave information about the Lawyer's Assistance Program. So the next step in this work is to develop a research plan to analyze the impact of the way these letters have been enhanced and expanded. Another area of work in this will be for the Office of Professional Competence to develop and incorporate an interactive self-assessment tool into the current learning management system. And this was actually, what's interesting is that this was per board directive that came out around the time of the Robertson report when he made his recommendation. So the timing was really perfect in this regard. So again, this idea is that attorneys can have a place where they can do a self-assessment of how they are dealing with client trust accounting issues. And this is all, again, for the purpose of improving their practice. Okay, so next let me talk to you about the respondent representation project. Again, as Dag mentioned, Professor Farkas found that respondents' representation significantly predicted attorney discipline, and Black respondents were twice as likely not to be represented by counsel as they engaged when they were under investigation and they went to State Bar Court. So the recommendation was to develop a letter to encourage representation, and to develop a metric to track our progress in this area, and to engage the Association of Discipline Defense Counsel for the purpose of seeing to what extent they can encourage or offer pro bono services for respondents. I'm pleased to share that OCTC and staff completed a personalized letter to encourage representation. So when OCTC reaches out to respondents to tell them that they are under investigation, request a response. There's also a separate letter that just encourages representation, explains the reasons why, explains the research in this area, includes a link to the ADDC. Right now, we are distributing this letter in a randomized fashion so that we can create a control and experimental group for the purpose of analyzing impact. And we'll do that study for about 3 to 5 months to analyze impact, in which case we'll look at the results and make modifications to the letter if needed. But the goal ultimately is that everyone will receive this letter. And we have finalized a metric for quarterly reporting to the Board of Trustees. So the next steps, like I said, is to analyze the impact, but also consider additional studies to analyze the impact and engage ADDC regarding pro bono and reduced service rates. And then finally, we are undertaking some research on the topic of dismissed complaints. Right now, the majority of complaints that the State Bar received are just dismissed in intake. They're dismissed with no discipline at all. And Professor Farkas found that the attorney discipline is correlated with the number of prior complaints, and Black male attorneys receive a disproportionate number of those complaints, many of which are dismissed without discipline. So the purpose of this project is to evaluate complaints that have been closed without discipline to determine whether specific issues can be identified that would allow for proactive preventative measures. So we've done an analysis of these cases, like I said, that have been dismissed in intake without discipline. And we found that 70% of them can be traced to just 3 categories: performance, interference with justice, and duties to clients. And again, so the purpose of this exercise is to go deeper into the specific allegations associated with these 3 big buckets of allegations that comprise the majority of cases dismissed in intake, and see whether to see how they can inform interventions to pilot test. And so our goal is to share the results and preliminary recommendations in early 2021 with the Board of Trustees. Okay, so before I move on to talk about the ad hoc commission, does anyone have any questions about what I've shared so far?
I have a question.
Sure.
So I recall there being discussion with regard to the issue of the overdrafting of trust fund accounts, that there is a suggestion that the threshold change from, I think, $50 up to $500. Did that happen, or did you guys leave it the same but institute these other measures like the letters and whatnot?
That's the analysis we did, and we concluded that we recommend, based on the analysis we did, that the threshold remain as it is.
Can I build on that a tiny bit, just because this was an interesting topic in terms of the question of the overdrafts. So by law, the overdrafts are reported to the Office of Chief Trial Counsel regardless of the amount. And we were able to get some data on, our concern was this. Our concern was that if we raised the level of the amount that Office of Chief Trial Counsel takes into consideration, that we would be sacrificing the State Bar's public protection function in support of we're trying to balance these 2 very important functions, our need to protect the public from attorney misconduct at the same time that we're seeking to ensure that there's not disproportionate discipline in the system. What we found in our analysis of the overdrafts is that the low-level bank matter client trust account overdrafts themselves were not the cause of discipline. It's very infrequent to see somebody who has a minor client trust accounting violation actually be disciplined for that. In fact, I don't know if there are any instances of that. What we do see, though, is that a cumulative number of these over time, and in fact, at the lower level, was found to be associated with later discipline. And so our concern was that we would be sacrificing an opportunity to alert an attorney who might be showing indications of having other problems in their practice management, to alert them that, you know what, we see these as a red flag. We're going to make you aware of it, and we're going to provide you with the resources to encourage you to be careful, to possibly engage in some client trust account training, and to make it more of a proactive, supportive approach rather than a punitive approach. So we've even, in the Office of Chief Trial Counsel, they've even sort of reclassified the way that they look at these, because a warning letter or a resource letter is sometimes considered a minor form of discipline. And they were very careful to say, no, we're going to send out these resources. We're going to encourage attorneys to avail themselves of these resources, but we're not going to call it that because we don't want to sort of further involve people in the discipline system, but we do want to provide them with the resources.
Excellent. Thank you. That sounds great. I really like to hear that you built in this early intervention mechanism to help attorneys do the right thing. So appreciate that.
I have a couple of questions too, and I'm sorry, there's a lot of noise going on right now. They're mowing the lawn and the phone is ringing, so I apologize for that. But I know you said that it was indicative of, you know, additional disciplinary issues down the line. Did you find those issues to be more business management related or truly fraudulent related? Because to me, that's very different.
I think that the most serious ones the difference that you allude to is I'm assuming precisely this. The most serious ones relate to fraud. They relate to commingling. They relate to misappropriation. And those were the ones that we would find with these lower level matters much further down the line, sometimes related to clustering of small amounts, were what these lower level bank matters appeared to predict. But I don't know exactly, though, the relationship between these practice management issues and the lower level client trust accounting reportable action bank matters.
Okay. And my second question is, can you all share with us, if you have it handy, the new warning language? And if you don't have it handy right now, could you share it with us later?
It's in the attach. We gave an example of one of the letters in the attachment to the November board agenda item. It's either attachment A or attachment B.
And that was in the email that I sent, maybe not yesterday evening, but the day before. There were many links about the attorney discipline system, plus that PowerPoint attachment.
But we can,
Did you send them as links or as PDFs? I know those PDFs sometimes take on strange names for posting, and so it might be hard to find.
I sent them as links as you sent them to me, Dag.
Did I reference them well? My email
I think you
to
did.
you.
I think you did.
So the November board meeting link then.
That would be the last link. The last link in the list.
Mm-hmm. Right, and it also an attachment there was the letter that is going out with regards to our encouraging respondent representation. So you can see that letter and an example of the letter from OCTC.
Michael has a question.
Thanks, Elizabeth. This is sort of building on one of Heather's questions, I think. And I know, thank you both, Dag and Lisa, for getting all of this data to us in a digestible format. I know that you're probably covering up a lot of the details that you spent a lot of time diving into. My question had to do with how the data about all of this deals with solo practitioners. I know that that was one of the things that the Farkas report had originally talked a bit about, that seems like there was disproportionate amount of complaints coming at solo practitioners, and whether that also, you're looking at that slice as it relates to either the trust account issues or the complaints that were dismissed at the intake stage.
I'm actually navigating, even as we speak, over to the November 2019 report, because I recall that the solo practitioners are in that equation. So the final regression analysis does include solo practice as a measure and controls for it. And in controlling for it, if it turns out to be itself a predictor, then it should pop out and you should see significance. My recollection is that it did not predict attorney discipline, that it did not have a statistically significant effect, but I'm double checking that in the tables. I should note, though, that we have long had some concerns about the way in which attorneys report whether they're solo practitioners. In fact, we don't have a good measure of that. So what we have instead is we have complaining witnesses indicating to the state bar, to the Chief Trial Counsel's office on their complaint, the size of the attorney's firm. And we have looked at some of that data and confirmed that it's not bad. It appears mostly to be accurate where we've been able to validate it, but it's probably not the best metric. And getting a measure of an account of the size of the attorney's law firms is a bit tricky. But I have the document up now. I'm just taking a quick look at firm size solo. Yeah, in the final regression model, there was no statistically significant impact on disbarment based on attorney firm size. But again, the complaint form itself, where this data is captured, asks, first of all, the complaining witness to provide the information, which is perhaps not their best source of information, and then also has basically three buckets of three categories of data. The attorney, where they can indicate whether the attorney is a solo practitioner working in a firm between 2 and 10 of between 2 and 10 attorneys, or working in a firm with greater than 10 attorneys. So it's a tricky measure at this point.
Kristen has questions as well.
I do. Thanks, Elizabeth. And thanks, Dag and Lisa, for all your hard work on this. So I had a couple of questions. Going back to the threshold amount for the reportable actions. I know when we met with Professor Robertson, Ryan and I, we talked about how the current threshold, I think, is $50. And he had originally recommended that we push that up, I think, to 500. Did we look at that in that amount and see if we could find that sweet spot of, if it's $100, it's not indicative of future discipline, but and still would eliminate, I think originally Professor Robertson indicated that if we raised it to 500, half of the reportable actions would go away. But we also, I heard you say that it is indicative of some future discipline. So I'm just wondering if we tinkered with that range, or if we just looked at 500.
We looked at the amounts, and so it was looked into amounts, and unlike the size of an attorney's firm data, this is actually much more. This is ratio level data. I mean, it's got the nice quality of being like something that you can count in increments that are equal distance from one another, that have a true zero value, and that go up from zero. There's some negative balances in there, which we were struggling with as well, which is like, wait a minute, there's a negative balance, or rather a negative balance of the overdraft, indicating that there was an overdraft on an account that actually had sufficient funds. So but it's a good data set, and it was pretty big. So it wasn't a matter of looking at it and saying, oh, up to 500 only, and we were only looking at 500 versus 50. It was looking at the full spread. And I think the thing that made us as staff particularly concerned about raising the threshold was that it was really at that lowest level, even down in the very mundane matters below 100, below $50. It was about those matters, and in particular the clustering of those when they happen either in quick succession, and multiples of those over a short period of time, or repeated low-level reportable action bank matters that appeared to be most predictive of future discipline.
Okay, thank you. That helps. And the other question that I had was whether we had looked at the effectiveness of the client trust account school in providing, I know that's one of the resources that's in the new letter, which is full of lots of good resources. And I'm just wondering, because I know we have talked in the past about alternative discipline programs on this issue. So I'm just wondering if we've looked at how successful that program is.
That is a terrific question. One that I like a lot.
Thanks,
And I
Meg.
think I think that Lisa will like a lot because it poses a research question, which is, no, it really does.
Sorry, Lisa.
You know, one directs people to resources, one hopes that they use the resources, and then one would like also to know that having used the resources, that they provide some protective effect. So Lisa, do you want to talk a little bit about our plans for trying to track? I mean, at the very first level, we need to track whether they're even like clicking on the resources.
Yeah, so we're planning to track all whether or not people click on the resources, each of the links, how many times they go back to it. That'll give us a sense of which resources are resonating with people. That'll inform, say, you know, revising the letter as needed, revising the order. We're working with Professor Scalar, who's an expert in this, and how to like message letters to certain audiences, particularly in the legal field. And at this time, we are thinking about how we're going to analyze impact of this. And so in the case of Client Trust Accounting School, we'll explore, you know, how much they're accessing it, and we'll explore whether or not this is having an impact. I think we'll need to consider, you know, privacy issues, right? With regards to like people accessing a course, how well they, you know, whether, you know, how much information, we'll have to see how much information we can gather, whether someone took a course, whether they completed that class, et cetera. And then how we can tie it back to analyzing whether, say, if it had a preventative effect on them. So that's something, that's part of the research plan we'll be developing.
Great, thanks, Lisa.
Novella has questions now.
Thanks. My first question was about the 70% data point. I was curious where the 3 categories come from. Like, is that something that the complainant checks a box when they're submitting their complaint, or is it something that the person who is reviewing it comes up with after reading the content of the complaint?
Okay, thank you for that question. So these are actually buckets that OCTC has to describe the like hundreds of allegations that are associated with the Business Professions Code and the Rules of Conduct Code. So when our staff are evaluating complaints, they look at a complaint and then they mark off like, okay, this has to do with this particular code with, you know, and this one and this one. And so there's like 400s, like, I mean, I'll just say there's hundreds of them. But then, so picture a database then that then has a separate data field that says, okay, these like 100 codes relate to performance. These, you know, 200 codes relate to interference with justice. So, and I believe that these, like the interference with justice and the duties to client, I believe that those 2 categories relate to the rules of conduct categories of, or the Business Professions Code categories of how they describe different allegations. Does that make sense?
Yeah, thanks.
Yeah, thank you. So our next step then is within each of these buckets to see like which of the specific allegations are the ones that are most alleged.
Got it.
Mm-hmm.
And then my other question just related to that was with the data point about Black men receiving a higher number of complaints. It reminded me of a study that Nextdoor did where they found that by including, they called it 2 types of like factors to disrupt bias, and one was adding friction and the other one was using objective criteria. And they found that if they presented people with like 3 prompts to slow them down before they actually submitted their complaint, and included in that was like a definition of like what racial profiling is in order to identify like, not just to say like we don't endorse that, but to specifically say what it is, because they were finding that people didn't know what it was. And then by adding objective criteria, that they were able to reduce the initial like racial disparity in the number of intakes they were getting.
Wow, that sounds great. And that sounds like exactly the type of research that interventions we would want to explore for this is exactly that. Because if like people are filing a bunch of allegations that are dismissed in intake for whatever reason, then the goal is to really not so much prevent people from complaining, because this is something we struggle with, because again, we have public protection mission. So it's not we're not trying to prevent, like decrease the number of complaints, but we just want when people make complaints that they're for a good reason. And so I can see this research going in that direction, is it in the sense of like coming up with a proactive way to like, when people are about to file a complaint, here's the things that you should consider. We're hoping to learn from like these allegations that have been dismissed to really inform that.
Yeah, and they like switched from the model of like, if you see something, say something, to if you see something, say something specific. And by forcing like the people submitting information to go into specific types of details and category, rather than relying on like, it was a Black person, they could get people to be more thoughtful about what types of complaints they were submitting.
I just wanted to add that I think that's a really great observation and suggestion. We have, as part of our risk-based proactive regulation work that we're doing, we have identified this issue of this vast amount of it's not just that these cases are dismissed in intake, leaving the public dissatisfied. It's a great deal of work for staff, and it takes away resources that might be available to investigate cases that do have merit. And so it's really a lose-lose situation, having this volume of cases that are filed. And now, as you've noted, I think it's a lose-lose-lose, because not only are there's extra staff work, the public leaves dissatisfied because they made a complaint and it wasn't treated with any, the State Bar wasn't able to act on it. And then it may involve this disproportionate impact on African-American attorneys. So we're looking into complaints that were closed without discipline, which is something that we haven't really looked at in the past, and is kind of a wide open area to try to understand better.
I don't see any other questions in the chat.
Okay, so let me just go ahead and switch over to the ad hoc commission to give a few more details building upon what Chair Solik shared so far. Oops. Okay, why am I not? Oh, here we go. So the ad hoc commission, the discipline system, the big picture charge of this commission is to take a comprehensive look at the attorney discipline system. And so the background to this is that the Office of Chief Trial Counsel has undergone much organizational change over the last 12 years in response to various different, audit reports, recommendations, et cetera. And so they've implemented, lots of changes, including improving access to the complaint process. They've enhanced their operational efficiency, improved the use of technology, and the Board of Trustees decided that the projects that we are doing to reduce discipline disparities is really building upon all this great work that OCTC has done. And so as a result, this is really a great time to do this comprehensive look at the discipline system. And so their charter in particular is to take inventory of all the changes that have been done, identify a set of processes, policies, and procedures to focus on, because like I said, they've had 12 years of policies and procedures and improvements. So the first step would be to review the inventory of changes and then identify which they will focus on. And so examples include like procedural justice issues, workload efficiency, etc. Then they're going to evaluate the impact, and they're going to ask these questions. They're going to ask, have these policies had their intended impact? What has been the impact of public protection? And when they're doing this, they're going to be guided by existing studies that we've done internally, and they will also commission new studies. And then finally, after a result of this comprehensive review, they're going to recommend additional or revised reforms. Members are going to be, to the commission, are going to be appointed by the Board of Trustees. The goal is that our members will reflect the state's demographic and geographic diversity. They're going to start their work early next year and present a final report in June of 2022 with periodic updates to the Board of Trustees. Here's an example. Here's the list of the stakeholder categories of membership. These are just guidelines for now. As you can see, there will be two. We're recommending two for the, from the Council of Access and Fairness. Here's the rest of the stakeholder categories, but again, these are just guidelines for now. And whoops, I think that's it. That's the last slide I have. Does anyone have any questions about these details about the ad hoc commission?
I have one question. So is there a website or someplace people can go to find information on how to apply to be on this commission?
Yeah, we'll be launching that early next week. So
Okay,
we'll have a web page and a link to the application.
Excellent. All right, well, thank you, Dag, and thank you, Lisa. If there's not anything else, I can move along to the next agenda item. Is there anything else that you guys would like to speak about?
I'm good. Thank you. Thank you all very much for your time. Thanks for your interest in this.
Thank you for the great questions.
All right, thank you, guys. All right, so next on the agenda, we have a training involving an overview of the Bagley-King Open Meeting Act and the requirements thereof. And Suzanne Grant from the Office of General Counsel will provide the training for us.
Hey. Hi, this is Brady Dewar also from the Office of General Counsel. Suzanne and I were just talking. I have an 11:30. I'm doing the next training about who should go first. Suzanne, how long do you think yours takes?
Sorry, I was unmuting. Probably like, I think maybe a little longer than a half an hour. I was gonna say like 40 minutes. So
it's okay. So would you mind if I
yeah, no, that's fine.
So Ryan, I'm doing the Prop 209 training. Is it all right with you if we just flip those?
Yes, that's fine. We'll go ahead and flip those. All right,
Great.
Prop 209 first.
And before I actually get into that, everybody, I just wanted to introduce you to another Office of General Counsel, Assistant General Counsel, Gagan Kaur. She's on the meeting with us. And for the past year and a half or 2 years, I've had the pleasure of providing support to COAF as well as other parts of the Office of Access and Inclusion. And we're going to share the wealth going forward. Gagan Kaur has been with us for about 2 years, and most of her work focuses on contracts, real estates, and collections work, as well as our complaint review unit, which reviews some of our discipline cases. But Gagan also has an interest in access, diversity, and inclusion work. So going forward, she's probably going to be the one attending most of these meetings and will be available to provide OGC assistance. Just a little bit about Gagan's background. She brings a really diverse experiences. Prior to the State Bar, she was at Reed Smith, a big law firm where she did commercial transactions, healthcare and compliance work, but also was involved in various initiatives like the Women's Initiative Network, Diversity Inclusion, and mentoring programs, as well as working with them on their diversity hiring and recruitment efforts. And in addition to her obvious background with the JD, she has a master's in public policy. So Gagan, did you want to say hi real quick?
Hi, everyone. Thank you, Brady, for that. I'm happy to be here, and I'm excited to be part of this council going forward, and providing any support I can on behalf of OGC. So thank you.
Great. So I just wanted to let you all know that that's a potential change, or at least addition to our staffing. Let me see if this is actually, believe it or not, let's make sure that share the screen. Does everybody see a PowerPoint.
Can you make it a little bigger, Brady? Maybe turn on the slideshow function?
Should have practiced this tech. I was so proud of myself.
Yeah.
Despite hundreds of
go.
Zooms, this is my first time actually controlling the screen. Can everybody see that now?
Yes.
Yes.
So we give this typically once a year, and I think I actually gave this training back in the springtime, but we've had some new members, obviously, and it's just a good background to know. So this brief training is on Proposition 209 and related restrictions on diversity activities. Proposition 209 was a ballot measure enacted by California voters in 1996, and it limits California government agencies' ability to pursue affirmative action type policies. The reason we give this training is that the State Bar is a public agency, and we just want you guys to be aware as we look at different initiatives the State Bar could take on to promote diversity, just being aware of some of the legal restrictions that we have to operate under. Proposition 209 was the news recently. It was possible that I wouldn't have to give this training anymore. Prop 16 aimed to repeal this, but well, I will just say it did not pass. So Proposition 209 is codified at Article 1, Section 31 of the California Constitution, and it provides that the state shall not discriminate against or grant preferential treatment to any individual or group on the basis of race, sex, color, ethnicity, or national origin in the operation of public employment, public education, or public contracting. So as should be apparent from the text, it's only implicated when one of those three things is involved, when the state government is operating public employment, public education, or public contracting. In practice, this means that Prop 209 is not something that we need to worry about in many COAF activities where we are working with the private sector or law schools on their activities. But it may be relevant when COAF is considering policies and practices of state agencies, including the State Bar. For instance, I know sometimes we discuss the diversity of the State Bar's workforce, and Prop 209 is definitely relevant to the sorts of activities and policy changes we can make there. Another area it might come up is oftentimes we will, in concert with COAF, enter into contracts, whether for research or other activities. And in choosing who we contract with, Prop 209 can also be relevant. But this presentation will focus on public hiring because that comes up the most, and the same principles really apply both to public hiring and the public contracting prong. So in hiring or contracting, Proposition 209 prohibits discrimination against or preferential treatment of anyone on the basis of race, sex, color, ethnicity, or national origin. Discriminate means to make distinctions in treatment, whether showing partiality, treating somebody more favorably because of their membership in one of those groups, or less favorably because of their membership in one of those groups. Preferential treatment means giving preference, which is priority or advantage of any kind to one person or group of persons over others. So it applies to differential treatment of both members of a majority group and members of underrepresented groups. So the California Supreme Court has recognized in looking at cases where these issues come up that the voter's intent was expressly to reverse discrimination, quote, based on race or gender. And unlike the equal protection clauses of the federal and California constitutions, which are also implicated if there ever is any differential treatment based on race or gender or membership in these groups. Unlike those clauses, Proposition 209 absolutely prohibits race-based discrimination and preferential treatment. So whereas with the Equal Protection Clause, discrimination or preferential treatment can be justified by a compelling government interest, that sort of balancing test does not apply with Proposition 209. However, it's not all bad news. Courts recognize a distinction between impermissible diversity activities that advantage one group over another and permissible activities that aim to broaden access for all. Supreme Court struck down rules in one of the seminal cases, high voltage case, They did strike down rules requiring city contractors in San Jose to either meet a quota for use of minority and women-owned subcontractors, or to provide subcontractors with special notice and procedural rights in the bidding process if they did not meet the quota. So the court found that no, by doing that, that's not permissible because you are treating subcontractors and contractors differently based on whether they're minority owned or not. But the court did explicitly recognize that that voters intended with Prop 209 to preserve outreach efforts to disseminate information about public employment, and basically that it did not take away the government's tools in making sure that you have a wide applicant pool and that people have equal access to the opportunities, whether in contracting or employment, that the government can offer. In another case, the next year, the Connerly case, the Court of Appeal provided further clarification of what outreach, recruitment, and hiring practices are permissible under Proposition 209. Again, any affirmative action programs imposing specific goals and timelines for hiring women or members of minority groups are impermissible, as are outreach efforts that provide special notice or benefits to certain applicants based on race, sex, color, ethnicity, or national origin. Those are impermissible, but outreach efforts that are broader and designed to broaden the pool of applicants are permissible. The court said a competitor does not have a constitutionally cognizable interest in limiting the pool of potential applicants with whom he or she must compete. Therefore, outreach or recruitment efforts which are designed to broaden the pool of potential applicants without reliance on an impermissible race or gender classification are not constitutionally forbidden. Research and analysis regarding employment of underrepresented groups or contracting with underrepresented groups is permissible. There's nothing, Proposition 209 does not bar studying these issues and doing analysis about what we can do at all. Race neutral policies promoting fairness and diversity may be permissible as long as the criteria used are not a proxy for race. This is sort of a kind of a very fact-intensive inquiry. So if we ever sort of approach the borderline, we'd want to definitely do some deep analysis. But the case where this distinction was made was a 2009 case called American Civil Rights Foundation versus Berkeley Unified School District. And in that case, what Berkeley did with its assigning students to school was rather than make decisions based on an individual student's race, they assigned them, they divided the city basically up into dozens of sort of micro neighborhoods, and they made sure that each school had a diverse sampling of the micro neighborhoods throughout the school, throughout the city, so that they promoted diversity across the schools, but without actually treating individual students differently based on their own race. In this case, it gets a little technical, but it does suggest some possibilities for increasing diversity in hiring without actually making decisions based on individuals. So that would be, making sure that we're recruiting in diverse geographic areas, looking at diverse educational settings, diverse practice settings, looking for diversity in other ways, basically diversity of experience rather than your actual membership in one of these enumerated groups. So just to go over a little bit more of how Proposition 209 plays out in practice. Some impermissible activities, again, are basing any hiring policy or decision on race, sex, color, ethnicity, or national origin, or gender. So, the prohibited activities include numerical quotas, goal setting, and this prohibition applies not just to policy, but to individual decision-making. So as an example, in the event that two equally qualified candidates were competing for a position, race, sex, color, ethnicity, or national origin could not be used as a tie-breaking factor. That couldn't, but the diversity of the candidate's experience could, what sort of perspective they would bring to the job, those sort of things could still be considered. Also impermissible is providing special notice or information relevant to hiring or recruiting only to members of certain enumerated categories when you don't also make that same information and opportunity available to all potential candidates. Also impermissible reopening positions or otherwise adjusting hiring procedures for the purpose of obtaining more candidates from any enumerated category, and providing incentives to managers for hiring individuals from any enumerated category. Those are impermissible. However, permissible activities include outreach to increase the applicant pool, posting job opportunities with minority bar associations and other minority affinity groups, providing that the same information is made available publicly. That is permissible. Also permissible participating in diversity and minority job fairs, providing that such fairs do not actually exclude participants on the basis of any enumerated characteristics. So that, still must be open to all. We can target outreach to underrepresented schools and geographic areas that are underrepresented in the applicant pool. We can advertise and distribute widely the State Bar's missions and its diversity policies and activities, including co-op work, to again, generate excitement and knowledge in diverse areas of the state. And we can use diverse hiring and interview panels. Also permissible is eliminating barriers to hiring, including any job criteria that may disproportionately impact underrepresented groups, while at the same time having no or limited relevance to job performance. And we can create hiring guidelines and interview questions that value diverse skills and experiences so long as the criteria are relevant to the position. Examples could include foreign language ability, demonstrated commitment to valuing diversity, such as experience increasing access to the legal system for underserved groups, experience working in diverse workplaces or serving diverse populations, demonstrated resilience in the face of adversity. Also permissible are activities and programs to reduce unconscious bias and in-group favoritism, including training, monitoring and analysis of female and minority involvement and success in recruiting and hiring, and finally, consistent with Title VII and the California Fair Employment and Housing Act, ensuring a discrimination-free workplace in order to promote retention and recruitment of a diverse staff. So those are sort of the yeses and nos in terms of what Proposition 209 allows public agencies to do in terms of hiring. And I know it's a lot to take in, but we just sort of want, at least in the background, you to be aware that, that this is something we have to think of in our work. And with that, I'm happy to take any questions. All right. And Elizabeth, I don't think I know we didn't post this, in fact, but I can make this available somehow for
Yeah, I can send the PowerPoint. We have a lot of PowerPoints, so I can send them out to the group after the meeting.
Awesome.
Thanks,
everybody.
I don't
Thank
see
you
any
very much.
questions. Yeah.
All right, is Ms. Grant available to provide her training? Does anyone know if she's here or not?
Yeah, she is here. Suzanne? Let me just email her.
Okay.
Oh, hi, this is Suzanne. I apologize. I was on mute and I was waiting for my turn. I apologize. Can everyone hear me?
Yes.
Yes.
So sorry, I don't have my camera on because I'm going to use the PowerPoint for my remote desktop, which doesn't have the camera. So I apologize that you can't see me. I hope that's not a problem. So let me share my screen. So anyway, I wanted to introduce myself. My name is Suzanne Grant. I also work in the Office of General Counsel with Brady and Goggin. And I handle issues and legal advice relating to the Bagley-Keene Open Meeting Act, which is what this training is going to be about. And that's an act governing how the State Bar conducts its meetings of its various sub-entities, the Board of Trustees, commissions, and committees, because we are subject to State Open Meetings Act requirements, and that's what this training is going to cover. And as members of COAF, this is a state body that is subject to the Bagley-Keene Open Meetings Act. So it is, important that you're familiar with the Bagley-Keene Open Meetings Act, and many of these requirements apply to you as members about what you are permitted to do and not do as members of the council. So I'm gonna share my screen right now. Second. Okay. Hopefully this works. Okay. So also before I go into the Open Meeting Act, as I just wanted to also make you aware that this PowerPoint goes over, what the Act legally requires and the Act right now. But since we are in a pandemic, the Governor Newsom has issued numerous executive orders that do pertain to meetings of different state bodies, because there's a lot of in-person requirements in the Bagley-Keene Open Meeting Act that obviously cannot be conducted safely due to COVID-19. So in a recent executive order, some of these requirements have been accepted or overridden during the course of the emergency. So during this training, I will also let you know which of these requirements are currently temporarily halted. Some of them are pretty obvious regarding the in-person meetings. So I just wanted to let you know the PowerPoint itself, though, does address the rules as they are typically not during a pandemic time. So just letting you all know that. So the State Bar is subject to the Bagley-Keene Open Meeting Act. The Bagley-Keene Open Meeting Act is a law that's been in place for many years, for a few decades in state government for state bodies. There's a corollary called the Brown Act for municipal and city bodies, which many of you may have heard of. Oftentimes, they're very similar. There's slight differences. So the Bagley-Keene Open Meeting Act applies to the state bar. That's what it's just called, the state bar. They don't specify what that means. We've interpreted it to mean, we'll get into what it means. It does not apply to the Judicial Nominee Evaluation Commission or State Bar Court. So they're specifically accepted from Bagley-Keene. This is just legislative intent of Bagley-Keene, that the purpose of it is to let the public know what the government's doing. It gives the public an opportunity to participate in public meetings through a public comment process. And the idea is that courts, which are looking at potential violations of Bagley-Keene, always construe Bagley-Keene in favor of public access, in favor of public transparency. It's so that the public has a right to know what the government is doing. These are just some nice quotes about public policy. We can skip that. So these are bodies covered by Bagley-Keene. So like I said, the statute that made the state bar subject to Bagley-Keene just says, quote, the state bar is subject to it. But we can interpret what that means by looking at what it means for something to be covered by Bagley-Keene. This is covered in the Bagley-Keene Open Meetings Act. It's a Cal Gov Code 111250, I believe, except if anyone wants a copy of it, I can provide that. But anyway, these are what's covered by it. So it's state boards, commissions, multi-member bodies created by a statute, boards, commissions, multi-member bodies that exercise authority that's delegated to them by a state body, certain advisory bodies, we're going to get into that, what that means, what an advisory body means, or official representatives of certain state bodies that serve on other boards that are supported by funding. The State Bar Board of Trustees is subject to Bagley-Keene under the first one, where it's a state body that was created by a statute. And most of the other State Bar entities, sub-entities, councils fall under the second one, that these are boards or commissions or committees. The second and third one, I apologize, that were either created by the Board of Trustees or delegate authority on behalf of the Board of Trustees. So these are subcommittees. Oftentimes, it's unclear whether a subcommittee that was created by the Board of Trustees is or is not subject to Bagley-Keene. So usually the criteria is that it either has to have been delegated authority by the board or is formally created and consists of 3 or more people. So that means that you might have a 2-person committee that exercises some sort of authority. They have some decision-making process. Even though they're only 2 people, they would be subject to Bagley-Keene notice requirements. Or more commonly, this is the most common one, in which is most of our sub-entities, subcommittees, and commissions, they were created by the board through some sort of resolution or formal act, and they consist of 3 or more people. So in this case, it would be, many of our, sub-entities were created like this, where the board will create it. It doesn't have to be created by a formal resolution, although that's typically how it's done. Anytime a board member or any committee that is subject to Bagley-Keene creates another entity through their official capacity, it's usually deemed to be formally created. So informally created subcommittees are not subject to Bagley-Keene. So that would often be things like working groups, or staff might create something. Usually that's always the key indicator whether or not it was formally created. If staff decides to create a subcommittee, they will not be subject to the notice requirements. However, if there is a majority of members of a state body that is subject to Bagley-Keene that's on this committee, then they would be subject to Bagley-Keene because there are a majority of members of that other group, and that itself creates a state body. I call them state bodies. That's the term in the Act. When something is subject to Bagley-Keene, that's the term we use, state body. So this is kind of what I was just saying, and I apologize, I skipped ahead, but this is about the term formal creation. So if, you know, usually the following are not formally created when it's a committee created solely by staff, or committee created by volunteers outside of a meeting. However, courts, like I said, interpret things for public access. So we construe formally created as pretty much any time any board member or state body member wants to create something, it will usually be deemed to be formally created. So what is a meeting? So only meetings are subject to notice requirements of the Bagley-Keene Open Meeting Act. A meeting is defined in the statute as any congregation of a majority of members of a body at the same time and place to hear, discuss, or deliberate upon any item within the jurisdiction of the body. So like I said, this is an important definition because only meetings are subject to the notice requirements of the Bagley-Keene Open Meeting Act. So meetings have to be properly noticed. Usually staff handles this, so this isn't quite as important for you to know as members, but you must know it in terms of what you might need to do to get to know that there's a meeting, to get all your information covered for that meeting. So the general rule is that there's 10 days notice requirements, 10-day notice requirements to post notice of the meeting. So we post the notices on the website. The notices have to contain certain information. They have to contain specific information about the date, the time, the location of the meeting. They have to have a contact person, and they have to have what's called agenda items, and that's what's going to be discussed during the meeting. So the notice has to have usually a short description of the agenda item. They have to be enough for the public to understand what that agenda item is going to be about. Only items on the agenda can be discussed. If it's not on the agenda and posted within the 10 days, they cannot be discussed. There's very specific, narrowly construed exceptions to that, which we'll talk about. The meetings have to be ADA compliant. That's one of these things that the executive order a little bit overrode. As you can see, we are doing a virtual meeting right now. We'll get into that in a little bit. There has to be an opportunity for the public to comment at every meeting, and there are certain exceptions to this notice requirement for certain emergencies. So this is one of the exceptions when I was saying about a notice that's an action item that's not on the agenda. So you can talk about something that's not on the agenda if 2/3 of the state body make a finding that there exists immediate need to take action that came to the attention of the body subsequent to the agenda posting. So this would usually occur in when you didn't know that something needed to be discussed, usually in emergency situations. This is different than an emergency meeting because here you already have the meeting has been agendized, but it's just something that you want to add to the agenda. Materials distributed at the meeting, they have to be open to the public unless an applicable exemption applies. So we usually look at the California Public Records Act for that to determine if it's a publicly disclosable document. The materials don't need to be posted with the agenda, but they should be made available. For instance, if someone did request this PowerPoint, it would be a public document. The records must be available at the meeting if prepared by the state bar, or after the meeting if prepared by a third party. State bar policy is that we do post the agenda items, as you might be familiar with that, 5 days in advance of the meeting with the agenda itself. So a meeting doesn't have to occur in one place, and I think this is one of the most important takeaways to this training as members of a body that's covered under Bagley-Keene. The series of communications may be considered a meeting. So that means it's important that you as members do not talk about state bar business with other members of COAF or other board members outside of a publicly noticed meeting, or that could be in violation of Bagley-Keene. It has to be with the majority of members. So you as a member might talk to one other person or 2 other people, and that might be okay. But the problem is once you talk to somebody and then they talk to somebody and they talk to somebody else, it becomes what's called a serial meeting. And that's a series of communications that taken together is considered a meeting, which would be a majority of members. That can include telephone calls, emails, serial briefings. So the rule of thumb is really, don't talk about state bar business outside of publicly noticed meetings to any members of the state body. So email communication may be publicly disclosable. So let's say, you do email another member about something, those will likely be publicly disclosable. There are exceptions, like I said, but many of them are publicly disclosable. So that's another reason we don't want to, we don't want people talking outside of publicly noticed meetings. The public has a right to see them. Always be mindful of what is written in emails regarding state bar business. This includes emails that might be on your personal devices. So if it involves state bar business, you would need to search it and possibly produce it in response to a records request. So always be mindful of what you're writing in emails. Not to say you can never email anyone. Like emails to staff is fine. Emails to a member about one specific thing is fine, but just keep in mind if you're emailing, you should not be emailing the entire members of COAF about issues that would constitute an improper meeting. So these are exceptions to a meeting, and these are things like, individual contacts between members of the body. So like I said, if you're just emailing one other person, attendance of a majority of members at another conference, a training, a workshop, open and publicized meetings regarding topics of state concern, purely social occasions, or you can also attend other meetings of different state bars, state bodies, as long as you don't participate. So this would mean, you could have a majority of COAF members attend a board meeting, and that'd be fine as long as there's, no discussion or deliberation about items pertaining to COAF during the meeting. So this is what I was just talking about serial meetings. There's also something called, a hub and spoke, as we like to call it. So that would mean, like, let's say somebody's sending out an email and and staff is saying, like, I want your opinion about the specific issue. So you email back to that staff member, give your opinion. Somebody else emails back to that staff and gives their opinion. A third person emails staff, and then staff says, "Oh, now I know how everyone thinks about this issue, and we're going to make a decision." That's not okay. So you shouldn't be doing that. You shouldn't reply all to emails. That would constitute an improper serial meeting. So a big exception is, staff can have individual conversations with with members of a committee, board members. That's fine. So you could ask questions to staff. Usually we encourage, if you do have something that you want to say to all the members, that you tell that to staff and then they communicate it to the other members of the committee. So, the idea would be, don't communicate your position on issues pertaining to business to the, outside of communicating that to staff. This was just a case that I put in here that really, I thought illustrated the principle I was just talking about, where that an attorney individually polled members of a body for their approval on something. And this is what I was just saying. The court found that this was not okay, that was a series of individual communications and that constituted a meeting. So that was something that was not allowed and violated Bagley-Keene. So these are just kind of hypotheticals. We don't have to go through them just because of timing, but these were just things about, when you should decide whether or not there is a meeting and if that meeting has to be noticed. So I'm just going to skip that just because I don't want to spend more time than we needed. So these are teleconference meetings. This, as I stated at the beginning, there are things in this PowerPoint that have now been overridden by the executive order, and this is one of them. As you can see right now, we are conducting a virtual meeting, which under Bagley-Keene would be considered a teleconference meeting. So Bagley-Keene does allow teleconference meetings as long as the location of every member calling in is on the agenda. And under the law, this was supposed to be so that the public could actually come to that location and see the meeting. So let's say you were having a meeting, you wanted to call into a meeting from your home under Bagley-Keene, you would have to notice your home or notice your office so that the public could come in. So that obviously is something that's not really doable during COVID. So the executive order has overridden that requirement, which is why you don't have to put your home or your business or wherever you're dialing in from on the agenda right now. Right now, it's just they eliminated that requirement so that as long as the public is able to access the meeting. So they said, okay, you don't have to put your address or your location on the meeting, just as long as the public has a way of interacting. So that's the Zoom link. So typically the bar for most of our meetings, or all of them, I believe, does use Zoom. Or I think some committees and commissions may use just teleconference. So that's what we're doing right now. However, this slide does say what the law is. So hopefully, I don't know what's going to happen, if it's ever going to go back to these normal requirements in terms of public access, but this slide does pertain to what the law says about how each call and location has to be noticed, and they have to be accessible to the public. Also, votes have to be taken by roll call, which is still the case, even though we have the pandemic. So anytime there's a vote, the idea would be the public needs to hear it, because obviously now things are done virtually, and some members of the public might not have access to cameras. They might not be able to see the Zoom meeting. We do put a dial in. So that's why when there's a vote, it has to be done by roll call. This once again, I might skip this because it's not really applicable to what's going on now, but this is about, noticing your location for the teleconference meetings, which currently is not applicable. This is about voting. Again, now we are doing things virtually. So voting is going to be done by roll call. There can't be any secret ballots, cannot elect officers by secret ballot. This really doesn't apply too much because we don't have in-person meetings where this would apply to. So these are special meetings. I don't want to get into this too much because these are very rare. This will be, usually done in conjunction with Office of General Counsel to determine whether a special meeting could take place. These are when there's emergency situations, but where 10-day notice is not enough time, where the state body has to meet right away. I know I mentioned earlier there was, voting with the 2/3 to add something to the agenda. That's a little different. That's when there has been a meeting notice and you want to add something. Special meetings are when you want to create a new meeting. A good example of this did happen right when COVID did start. We had a few need for special meetings when the board needed to meet on short notice to handle various issues. So when this happens, there has to be a finding of 2/3 of the state body that the 10-day notice would impose a substantial hardship, or where there's immediate action needed to protect the public interest. There has to be at least 48 hours notice. So special meetings, they are a little limited. There's another type of meeting called emergency meetings, which we'll get into, that are a little broader. But special meetings, not only do you have to have that, not only do you have to show that you needed to have this meeting less than 10 days, but there are only certain topics that you're allowed to talk about. And those are whether there's pending litigation, proposed legislation, disciplinary action, or certain action taken about licensing exams. So they're pretty limited. So it has to fall under one of these topics, and you need to have a finding that you need to take to have a meeting within less than 10 days. Emergency meetings are much broader. So they're when there's, a rare instance when there's a crippling disaster or there's work stoppage that would severely impact the public health or safety. It's not limited to just those topics I talked about. It could be about anything. There's only 1 hour notice. Notice, like I said before, is notice we posted on the website. There's also some technical requirements about, posting in newspapers that we don't follow that. We just posted on the website. We did have this during COVID. There was justification in the sense that there was, this public health disaster. And before COVID, when I gave these trainings, I'd say, this hardly ever happens, but now we know it did. So, that we did use this a few times in March. So public comment. So the state body must have an opportunity for members of the public to address the state body during any item that's on the agenda. So the state body does have some discretion in terms of how public comment is allowed. They can adopt reasonable regulations to govern the time for public comment. So usually they can say each speaker might have 2 minutes. They might say if there's a lot of speakers, we know it's an issue that's going to engage a lot of public comment. They could say public comment's only going to be 20 minutes and just have a hard stop. It's pretty, up to discretion of either the chair or the state body. Public comment's not required if there was a substantially the same item was already discussed and already had public comment on. Public comment is, under the act, it is supposed to only be allowed for items that are listed on the agenda, but often, we don't want to limit, if the public does have an issue regarding the bar and they want to talk about, usually we encourage the public to do that, but that's up to each individual state body how they want to handle their public comment. One other thing about public comment, often, people will, when we know there are a lot of them, sometimes the body might say we encourage public comments in writing. So sometimes, that's something that could be done as well. So it's a way to say, we want to consider your comment to make sure it's considered. You might want to put it in writing. Once again, that's up to the state body how they want to do that. So social media also might create an inadvertent risk of Bagley-Keene violations. So that's always something to be careful about if you do have a social media platform and you're in your official capacity as a state body member. You want to avoid commenting on issues that involve the bar on social media. You might, if you like another member's point of view about something that involves the bar, that might inadvertently create a meeting. So you want to, or reposting something or retweeting something. So you want to be careful with that. Generally, the rule of thumb is try to avoid that if you can, because it might show your position on something to the public that might constitute a meeting. Closed session are a part of meetings that are not open to the public. That means, that means that you can have staff members, sometimes you can invite guest speakers, but they're not open to the public. The grounds for closed session are very limited. They're laid out in the Bagley-Keene Open Meeting Act. There is a provision that says they're also provided for under state law. So that means besides Bagley-Keene, the California legislature could say, just for the state bar, we want to have these items discussed in closed session because they're important not to have the public hear. And those are in the Business and Professions Code, and we'll talk about a few of them. Closed session must be held during a regular or special meeting. They cannot be scheduled independently. So what that means is they have to be noticed. So the same way we have our 10 days notice, you also have a 10 days notice for closed session. Typically in meetings that do have a closed session, there's usually an open session part, then a closed session. However, you can just have a closed session meeting. The agenda must identify the specific grounds for closed sessions. You have to, the same way you identify what's going to be discussed during open session, you also have to identify what's going to be discussed during closed session and cite the specific statute that justifies the basis for the closed session. So these are a summary. We're not going to go through all of these, but these are grounds under Bagley-Keene for closed session that usually apply to the bar. And these are things like, the big ones are like appointment, employment evaluation or dismissal of a public employee, preparing or approving an exam. The exam, as you might imagine, is the bar exam. When you want to talk about creating the bar exam or grading of the bar exam, that's in closed session. An unwarranted invasion of privacy of an individual licensee. So that might be, when we're talking about a disciplinary case or applicant to the bar, things in negotiations regarding real property, investment decisions, sessions regarding salaries, salary schedules, which, might relate to, collective bargaining issues with the union, matters that might pose a threat to criminal activity, pending litigation, which would be, getting attorney-client privileged advice regarding litigation, and discussion regarding a draft audit report. Yeah, do you have a question?
Yeah, this is Donna. Before you go on any further, I think we forgot to warn folks that Suzanne is from New York, and so she is quite a fast talker.
Oh, sorry. Yeah.
So since you have the PowerPoint up, I'm certain you're not looking at the chat. We have a question from.
Oh, I'm sorry.
One of our COAF members asking whether or not COAF can take action on public comment, and I just want to make sure that you cover that.
Oh, sorry about that. And obviously I do talk quickly and I apologize. So please, tell me if you want to slow down or ask any questions. So when you mean by action on any public comment, I assume you mean if the public brings up something that's not on the agenda, if you can take action on that. And the answer is probably no. You can only take action on something that's been agendized. So if there is something that comes up and the public brings up something you want to take action on, the idea would be, you have to put that on the next meeting. You would have to agendize that. Does that answer the question?
Yes, it does. Thanks a lot, Suzanne.
Okay. So the next slide is, sorry, my PowerPoint seemed to, there we go. So these are grounds that are in the Business and Professions Code itself. So as I was saying, they said, under state law, the state can make its own exceptions to, not exceptions, but grounds for closed session. So these were ones that were specifically designed for the bar, and these mostly relate to CBE. These would be, or the committee of, what is it? The legal specialist committee that the board of legal specialization. That's it. It escaped my head for a minute. So these are appeals from decisions of the board, preparation, approval, grading of the bar exam, which is also in Bagley-Keene itself, which I just talked about, matters related to consideration of moral character or information about a law school's operation that constitute a trade secret. So these I put in here, now they're not so recent anymore, but this is an older PowerPoint, but these used to be grounds for closed session that aren't anymore. So some people have been on these boards or committees a long time. might think of this as something that's still allowed, so it's still in this PowerPoint, but appointments to state bar committees can no longer be done in closed session. It used to be able to be done in closed session. Appointment or dismissal of a non-employee consultant or officer of the bar, those also can no longer be held in a closed session. So these are just minor changes. So now when we want to make appointments to committees, they have to be done in open session. So these are remedies and enforcement in terms of what happens when there is a violation of the Bagley-Keene Open Meeting Act. People usually need to bring a writ. So that means they have to make an action in Superior Court saying that the state bar has violated Bagley-Keene, and the usual remedy they seek is to overturn an action or decision. So they could say, they took action on this item, they didn't properly notice it, or they didn't, follow Bagley-Keene requirements. So we want to overturn it. The next one's a court of public opinion. This is a common one where you'll get a letter or it'll be in the press that the state bar violated an aspect of Bagley-Keene, and that will make us look, not great to the public, seeing that we didn't follow the rules like we were supposed to. We do get people that do, watch us, and we do get letters and members of the public saying, was this correct? I'm not sure if this complied with Bagley-Keene. So it is, it's very important that we comply with it. Civil action. So as I was saying, they might take a writ. It could expose us to attorney's fees or cost for the violation, press interest, and there is potential criminal action. This is very rare. This is when there's an actual willful violation of knowing misconduct where you knowingly violated Bagley-Keene. Technically, the statute does provide there could be criminal activity, criminal actions for that. So does anyone have any questions about the Bagley-Keene Open Meeting Act? No. Okay, so thank you. And if, I would say also, by the way, if you have any questions, I would contact staff. They can always contact me. But, I would always, staff is always the first resource to go if you have any questions or you're not sure if something's okay, to ask staff. And yeah, thank you very much.
Thank you, Suzanne.
Thanks.
Thank you, Suzanne. All right, so seems we're at 11:50, so 10 minutes before lunch. Sorry for my daughter talking in the background. So should we just break for lunch now and reconvene, offsite at the 12 for the
yeah, we can. We actually are running way ahead of schedule. So thank you everybody for being so efficient this morning. So we can, take a little break. I will start the lunch breakout Zoom link in a moment, and then we can probably take a little bit longer lunch and reconvene at 1 o'clock because both those trainings were so quick. So I think that if that works for everybody, we can do that. And actually, Donna did chime in a little earlier, but our interim executive director is here has joined us. So I just want to acknowledge Donna and make sure that everybody was able to see her. So
sorry I'm late, folks. We have a committee of bar examiners meeting and your meeting going on at the same time, and I'm trying to juggle the two. That's one thing that's oddly easier in person when I could run down the hall. So I'm glad to be able to participate with you as much as I can today.
Thanks, Donna.
Thanks, Donna.
Okay.
All right.
So so we can take our lunch break now, and we'll resume at 1 o'clock. And I'll see folks who are join the other link on the
lunch ones, right?
I'm sorry?
We're dialing into the lunch ones though at 12?
Yeah.
Okay.
Thank you.
Thanks.
Vicky? Okay, great. And Vicky, should we pause the recording?
Yes.
Thank you.
Let me get out of this real quick.
Elizabeth, we can end this one and then come back at 1, right?
Yeah, so because Vicky will keep this one open for us to come back to.
Right, thanks.
Thank you.
We had a delicious lunch. And so we're going to be moving into the section of the agenda where we are discussing discussion and action items. And here it says that we're going to be referring to the work plan. And so you guys should be able to access the work plan on the agenda, but I'm also going to post a link on the Zoom chat so you can go directly to it. This is, there we go, panelists and attendees. There you go. And so if you go to that link, the work plan should come up. And moving to the first item, focusing on the work plan, is an update on Diversity Summit planning for 2020, which falls under Goal 4 and Objective L. And Elizabeth will provide an update.
Thank you. So what we're going to do is we're going to have staff and some of our working groups provide some updates, and then after that we will pause, I think, to have some liaison reports, and then we will take the rest of the meeting time to talk about the 2021 work plan, just to kind of frame the afternoon for everybody. So for our Diversity Summit planning, as you know, for 2020, we made the decision to have sector-specific summits because we were finding in our first two summits in 2019 and 2018 that each sector really had very specific issues and very specific solutions to diversity and inclusion. And so for this year, we broke out into three sectors: the private sector, nonprofit, and government. And so we held the private sector summit on September 11th. And I want to thank Heather for moderating our wonderful panel. And also to Sal, who provided us some feedback on our agenda. And so I think that it was a really great panel, and those that you were able to attend, please chime in. I think given that we had to convert from an in-person meeting to a Zoom session that was really truncated in terms of timing, I think it was very successful. We were able to share our diversity report card, get some feedback on it, have this really amazing panel with Alan Braverman from Disney, Terrence Evans from Dwayne Morris, and Hyland Chen from Munger Tolls, I think, and with Heather moderating, and it was really fantastic. And then we had some breakout groups to talk a little bit more intimately, because we had, I think, about 50 people who were able to join us. So I think building off of that success, we will be holding our nonprofit diversity summit next Friday. So if you're available and interested in joining, you should have all received the registration link, but if not, please let me know and we can get that to you. The format for the nonprofit diversity summit will be a little bit different. We are partnering with the Legal Aid Association of California for the summit. And so we will similarly present the diversity report card. We'll also have a presentation of the Legal Aid Association's 2020 report on recruitment and retention in the legal aid sector. And then we will have a panel presentation, and then actually quite an interesting training by one of our State Bar grantees called WorkSafe. Their training will be on, kind of looking at creating safe workspaces for legal aid staff, which would include policies and creating policies with a race equity lens. So I think that might be interesting to some people. So if you're available, it is next Friday at 1 p.m. So I encourage you to register if you're available. And then we will be having our government sector focused summit probably early next year. We just, given the pandemic, couldn't squeeze it into 2020. We, of course, welcome your feedback and invite any of our new members to join in helping us plan for the government sector summit if you're interested. So,
thank you, Elizabeth. Sorry for sharing a link that didn't work outside my computer, but I think someone provided a link that does have the document accessible. Yeah. All right, so next item on the agenda is item 7C, update on plan to address law school retention, and this will be presented by Crystal Bunda.
Hey everyone, Elizabeth, did you have the PowerPoint ready?
Yeah, I am sharing my screen right now.
Perfect, thanks. All right, Great. Good afternoon, everyone. I'm going to be presenting a brief update on behalf of the Working Group for Law School Retention. Again, this is in support of Goal 4, Objective H of the BOT Strategic Plan. Members of this working group are Shalak and Sal. Go ahead, next slide. Just a quick reminder of the Law School Retention Survey's purpose, which was threefold. These bullet points were shared and communicated with the law schools, both via email and to the Law School Council and the CS BARS meetings. So just to summarize, first is to learn about existing efforts to recruit and retain diverse law students in the California's law schools, develop a resource to summarize current efforts and highlight best practices, and finally support the overarching goal to achieve a diverse statewide attorney population that reflects California's population. All right, great, next.
Sorry, there you go.
Just a couple of details. Since our last meeting in August, the Law School Retention Survey was finalized and administered on October 27th to all 53 ABA accredited, Cal accredited, and registered law schools. As of December 1st, we received 32 surveys, so we're at a 60% completion rate so far. The initial deadline was November 20th, but taking into account the holiday and we wanted to encourage full participation, we're extending that deadline to December 11th. These are just kind of these areas and sections where the information was collected in those areas. Both Sal and Shalak gave feedback, and then we beta tested, just kind of a brief reminder from the last time we met. So student recruitment efforts, mentorship, financial support, and key performance indicators. Great, and just for next steps, responses are coming in. We're really going to take a deeper dive and analyze after the December 11th deadline. And just considering that the other attrition data from the annual report in 509, we'll be taking that into consideration as well to eventually develop a best practice guide or resource for all law schools. So the working group will be happy to provide an update at the next COAF meeting. Happy to answer any questions. Yeah.
And just to provide a little bit more context, the annual report is a report that the State Bar requests from California accredited and registered law schools. And the 509 report is the report that the American Bar Association, the ABA, requests from ABA accredited law schools. And for 2020, this is the first year where we've tried to align kind of the demographic and other categories with the ABA report so that we can more easily compare the two to have a better picture of California law schools.
Yeah, are these reports publicly accessible, like on the website?
Yes. Yes, the 509 reports are available on the ABA website, and I believe the annual report data is available on the State Bar website as well.
Okay. All right, if there's nothing else, we can move along to the next agenda item, but I want to make sure there's no further questions. All right, well, thank you, Crystal.
Thank you.
Moving along to item 7D, an update on efforts to institutionalize diversity and inclusion goals in bar exam, question development, and grading. All right, and the person who will be updating us on this is Program Supervisor Dewan Nguyen.
Hi, everyone. Good afternoon. Again, my name is Dewan Nguyen. I'm a program supervisor in the Office of Access and Inclusion. I just want to welcome all the new COAF members. I'm very excited to meet you virtually and looking forward to working with everyone this year. So I'm the primary staff for this working group. I'm going to share just a few PowerPoints, so bear with me. Let me share my screen. Oh, Elizabeth, it's not working. Would you mind? I don't. Can you pull up the slide, Elizabeth?
Yeah, I will. Hold on just a second.
Not sharing.
Okay.
So this working group, this bar exam question development working group, Heather Anderson and Sal Torres are the two co-op members that are working with me on this. And the main goal of this working group is to identify ways that kind of diversity and inclusion principles can be institutionalized in bar exam development and grading analysis. And we made a lot of headway last year. This working group, we worked really closely with the Office of Admissions to kind of identify strategies and policies for them last year to kind of increase their grading applicant pool and their actual graders, because the graders lacked some diversity. So you know, we were able to assist the Office of Admissions in adding some demographic questions to the grader application. We also, through COAF's recommendation, they are now creating a hiring matrix to mitigate some of the biases in the hiring of graders. And they've also now instituted a requirement that all of their graders have to implement implicit bias training. So we're still working with the Office of Admissions to kind of further develop some of those policies. Also part of this working group's goal is to review policies and practices related to the actual development of the bar itself. So that's kind of like the phase 2 of our working group, and we're starting to begin that process right now. And part of that process is reviewing the bar exam differential item functioning report and formulating some recommendations. And if you're not familiar with the diff report, there was a presentation by somebody from the State Bar a few COAF meetings ago, but the diff report attempted to kind of assess whether different groups had similar overall, whether different groups with similar kind of overall scores tested differently in different sections, and if those kind of anomalies could be explained through some theories, perhaps it's gender or racial bias. I don't know, we're not so far along that there are theories yet, but we're starting that process in terms of looking into it. There is a formal, oh sorry, Elizabeth, can you go to the next slide? Yep. There's a formal working group to review the diff report. And the working group is going to be comprised of 4 members of the Committee of Bar Examiners and 2 COAF members. On the COAF side, Heather and Sal will be attending to represent COAF. And the first inaugural meeting for that diff working group is December 18th. So we will have much more to report at the upcoming COAF meeting. And Heather, Sal, I don't know if you wanted to add anything.
No, I think that was a good summary for where we are right now.
Yeah, you covered that well, John.
And we're happy to take any questions. Okay.
Any questions? All right, seeing and hearing none, we will move along to the next agenda item. Thank you, Dawn.
Thank you so much.
The next item is item 7E, which Elizabeth will provide an update on the request from the Committee on State Bar Accredited and Registered Schools for feedback on proposed rules revisions.
Thanks, Ryan. So this is a really quick update. CS BARS, the Committee on State Bar Accredited and Registered Law Schools, recently wanted to revise their accreditation rules for California accredited and registered law schools. They had not done this in over 30 years, I believe. And so it was a really great opportunity for COAF to come in and provide some expertise and feedback on how to include diversity, equity, and inclusion into the accreditation rules. So thank you to Kristen and Donna Shealy, who has termed off of COAF, for participating in that. We did a lot of wordsmithing, but I think CS BARS was really pleased with COAF's involvement and with the contributions to include DEI in their accreditation rules. And so at the November meeting, the board approved the Committee of Bar Examiners' request to put those rules out for public comment. And so they will be out for a 60-day comment, and they'll be out now. They're out now, and I believe the comment period will close in January. So just wanted to let you know if any of your constituencies might be interested in commenting, that comment period is open. Kristen, do you have anything to add on that?
No, I mean, I know Natalie's not on the call, but you know, Natalie was instrumental in helping us out, and Donna's, you know, great work and insight on wordsmithing and I think that they are, I think they're important changes to add DEI rules into the accreditation and registration requirements. And so, and I think that there's a lot of positive feedback from those law schools. So.
Thank you.
All right, any more questions or comments? All right, thank you, Elizabeth. And seeing and hearing no further questions or comments, we'll move on to the next agenda item, which is 7F. Senior Program Analyst Erica Carroll will provide an update on modification of elimination of bias MCLA rules and implicit bias MCLE training.
Thank you, Ryan. Good afternoon, everybody. Just a quick update on the MCLE working group. So I am the staff member assigned to that, and the co-op members are Judge Esther and formerly Connie Broussard, who termed out. It's my understanding that Novella and possibly some other co-op members have expressed some interest, and we definitely would welcome new member participation in the working group this coming year. So the MCLE working group's main focus of late has been on Objective M of the strategic plan. So the goal is to adopt revised MCLE elimination of bias rules by the end of this year. And I am pleased to report that we have actually achieved that already. So at COAF's last meeting, after the proposed rules came back from public comment, COAF made a final recommendation to the board to approve the new elimination of bias rules, and the board did so at its meeting in September 2020. So just briefly, the new rules increase the elimination of bias hours requirement for attorneys from 1 to 2 hours every reporting period. It creates a subtopic focused on implicit bias. So at least 1 hour needs to be focused on implicit bias for attorneys, and it prescribes some content requirements and outcomes for instructors. So instructors will need to incorporate actionable steps for attendees to recognize and address their own implicit biases. These rules have been published already, so they're already out there, but they won't actually become effective until January 1st, 2022. So MCLE providers will have to comply as of that date if they want to offer implicit bias courses, and then attorneys will have to start reporting. They'll have a little over a year and report in February 2023 if they're part of that reporting period with the increased hours requirement. And so this is consistent with the new statute under Business and Professions Code section 6070.5, which was also part of Objective M. So we met all those requirements of considering a subtopic, expanding the hours, and then making sure that the timeline is in tandem with the new statute. So we're really excited that that was approved and is moving forward. And then the other main project that the working group is focused on is an online elimination of bias MCLE course. This will be a 1 hour free MCLE with an implicit bias focus. So attorneys who are licensed in California will all be able to access this course when it is ready. The board approved this back in March 2020, and we're finally kind of starting to get into gear in progressing with the course. So we have brought on a content expert and an e-learning course designer. Our content expert is Catrice Monson. She's a former senior vice president at CBS for diversity and inclusion. And she's also a managing director and co-founder of a company called Right Size Media, which also focuses on diversity and inclusion. So she's bringing a wealth of knowledge that we're really excited to work with her, and thank you to Heather. We know many of you provided possible content experts who we reached out to, and Heather suggested Catrice, and so we appreciate all of you for the suggestions, and thank you, Heather, for getting us in touch with Catrice. And our e-learning course designer is InfoPro Learning. They have partnered with the State Bar previously in developing online courses, most notably our new attorney training program. So they are very familiar with the State Bar and our processes, and we're ready to hit the ground running. So where we're at right now is sort of in the outlining and project planning stage. And we are hoping to move forward in earnest in the next few weeks. So it should take about 8 to 10 weeks once everything's sort of fleshed out. to reach our completion date. So that should give us plenty of time to get everything up and running for attorneys to help them meet the new increased hours requirements starting in 2022. So in tandem with developing the course, we're also going to be focused on developing some learning outcomes. And then once the course is finalized, the goal is to revisit the curriculum every 3 years or so to make sure that the content is up to date and continues to remain relevant. So those are the two things we've been focused on lately.
All right, does anyone have any questions for Erica Carroll?
No questions, but I'm so excited because Catrice is awesome. Now I want to see the content. Like, I'm so excited about that. So that's great news.
Thanks, man.
Excellent. All right, so moving along to the next agenda item, 7G, we will have an update on the early pipeline to the profession outreach material development. And this update will be given by Kristen.
Thank you, Ryan. As a refresher for everyone, Sal and I have been working with State Bar's communications folks and with Dan to update what used to be called, I believe, So You Want to Be a Lawyer, or something less catchy than what we have worked on, what Sal came up with, which is Be a Lawyer, Make a Difference. And so we updated and worked with communications to update this brochure. And what you're seeing now, I guess, is the online version, Elizabeth.
Yes, yes.
So we one of the big changes is that it's now both in paper and online. We refreshed the language and the look. I know we don't have the old version here, but if you saw the old version, you'd know why we refreshed it. In addition to refreshing the look, we added new folks. Chief Justice Saki Yui's on there. There we go. Yep, there she is back there. We added David Kelly on, who you'll hear a little bit more about in a second. We added Lisa Cisneros, who has a fascinating background both in rural and LGBT issues. Alicia Valencia, who works for CNA Insurance. And then Alexandra Chen, who founded Harvard's LGBTQ+ advocacy clinic and is transgender. So we really updated the people that we have here to speak to a diverse group and a younger demographic. The other brochure was at least 20 years old. So this one is a little bit more updated. We went through and updated the resources links and really talked about what people could do with a law degree in a more contemporary fashion than we had before. So we talk about the kinds of opportunities that being a lawyer can open up for you. We also go through, as you can see, the pathways to becoming a lawyer, both the traditional path of law school and then the law study program. And we give folks, tips. If you're in community college, this is what you should be doing. This is high school, this is what you should be doing. If you're not in school and you didn't graduate from college, there is a way for you to become a lawyer in California. And so, we really tried to speak to all of the ways in which we can get a more diverse group of people into the profession, and whether that's through law school or through other non-traditional avenues. And the paper form of the brochure is as phenomenal as the online version, and it really came out, I think, better than we had hoped, and that is all thanks to the State Bar's folks and Sal. I'm not going to take any of the credit, but it really is great. I don't know if we'll have paper copies that we can, if we can ever see each other again, maybe we can actually have a paper copy in front of us.
So actually, It just got saw come through in my email, like a near final version of the paper copy that looks similar to this, but is obviously in a paper version. And so I think if people are doing in-person events, when that's appropriate, we can make some available to you. But I do think we will rely heavily on this digital version, which I think is beautiful and a real upgrade from using the one that was old. So thank you, Kristen. You deserve credit, and Sal for your time and efforts on this. Michael has a question.
I think it looks really fantastic, and I was trying to find it, but is it live yet, or am I?
I believe it's going to be. We are when I have the public link, I can send it to everybody to share.
Fantastic.
And the links on the links within the brochure are also clickable. So, you know, the resources that, you know, if you're looking at the online version, you'll be able to click on those resources. And as you can see right there.
There you go. That's it.
Yeah.
Yeah. This is like if you saw I mean, Kristen, you were like so nice about it, but I'm telling you that the last brochure felt like it was made in 1920. It just did not represent. I mean, I love the State Bar, but frankly, what this group should feel very proud of the work that this committee did, because we can all hold this now high and say, look, this is what we're about. I think that's great that we've upgraded this, because now the 1920s look is gone, and you can just imagine what 1920s was like for lawyers. Now this looks like you think about inner city. I mean, I'm an inner city kid. I grew up in the streets of LA. If somebody had asked me the question, do you want to be a lawyer? I'd say, hell no. Now seeing this, it makes the youth and the people we're trying to target think like, you know what, I never thought of it, but yeah, I want to make a difference too, because this is the climate of conversation we have now. So it's really speaking to the youth and to the people that are interested in this now. So really kudos to the staff at State Bar. They really helped guide us. And Kristen and I just had such a great time working with everybody on the staff, and really super, super product. I'm really proud of this one.
Yeah, it really is phenomenal.
Thank you, guys. It looks like Heather has a question. Yes.
And Novella, yeah.
It's so beautiful. I'm so excited. This is awesome. Thank you guys so much. This is awesome. So my question is, I'm going to want to share this everywhere when it's live. And then this kind of runs into the Bagley Keene thing, right? When I posted on social media, can none of you comment when because she just said, like, don't post about bar business, and this is bar business. But I think we're all going to want to say, like, this is awesome. So I don't want that to seem like our opinion on something. I wanted some clarification.
I can ask about that.
Okay.
No, actually, I think what the meaning is for that act is bar business that we have not yet made a decision upon. But this is something that's actually, if I can say, I think it's true, right? It's a completed project, subject to it being public. It's completed. So I don't know that. I mean, I don't know, Kristen. We're not doing any more changes to this, right?
No.
So it's done. So I don't. But again, let Elizabeth check. But I think it's probably okay. I mean, I'm excited. I want to go post it now.
Right.
I'll wait.
Okay.
Thank
and then
you.
Novella?
Yeah, I think it looks awesome. I'm really excited to post it as well. And I was curious if there's like a youth targeted plan to push it out, like with like TikTok and all the new stuff that young people use.
That's a good question. So at the State Bar, we're not really geared towards the youth or a social media campaign involving TikTok, but we are partnering with California Lawyers Association and California Law, and they both have media campaigns that we want to plug this into. So that's the plan.
Can I also make a recommendation as well, that to the extent the State Bar or knows of, or I guess wouldn't be affiliated with, but may have communications with affinity bar associations that I know do a lot of outreach and pipeline work, like sending them this and encouraging them to send it out and use it in high schools and wherever that they may go. I think that is a great way to disseminate it without it necessarily being the bar's
responsibility to disseminate.
Absolutely, that's a great idea.
This is Pat. We'll probably ask you to, we'll need the online version and we could send that out for our Pathway Summit, but also there's a major conference every March statewide. It has like up to 3,000 attendees. It's called the Educating for Careers Conference. All the high schools and so forth attend that. And that should be a virtual or online resource for that. But we also have a resource fair where we would probably need hard copies to hand out because people wander through the fair and they pick up information. So I just wanted to give you a heads up. That's in March.
Great. Michael?
This is probably covered by what Pat just said. I know that there are also in various cities programs where it's reach education programs at high schools. I know that Sacramento has one, a pretty established one, for example, and this seems like a good opportunity for partnership to educate and to plug it with some students who are already open and thinking about this. So again, I think that this really looks great.
Yeah, I'm a mentor in the McClatchy Law and Public Policy program, and this is certainly going to be distributed to the kids in that program and hopefully others as well.
I see the Instagram tag on already, so that's good news.
Definitely high school student friendly with the Instagram stuff.
Yep.
All right. If there's no further comments or questions, I can move to the next agenda item. I'm seeing and hearing none. Thank you, Kristen. Elizabeth is going to give an update on the attorney video project.
Yeah, so thank you to Ryan and Heather for taking the time to complete our first video. So the video is with the GC from the Golden State Warriors, David Kelly, who you just saw in the brochure. We are just finalizing the public link for the video. And so I can share that out to you. It's about a 25-ish minute video. But we're gonna, our communications team is gonna try to take snips of it, like, you know, whatever is appropriate for social media. I don't know, 30 seconds, a minute. I'm not that savvy in that, but take some snippets of it so that we can share it out on social media to link to the longer video, to link to the brochure, kind of along the same lines of doing outreach to young people about the legal profession. I think given the circumstances of the pandemic, I think David Kelly, Ryan, and Heather really went above and beyond to complete and produce the video. So I wanted to thank you both for that, and invite your comments as well.
Thank you, and kudos to Heather, who she's the resident expert on this kind of stuff. So her ideas were excellent, and I was just taking cues from her.
Ryan led it all. It was interesting. It was very different to produce and film something in a pandemic, but I think we tried to pull it off the best we can, and it will certainly memorialize this time period for the kids, for the students, including all of us in masks as we were filming. So, but we utilize that to talk about the legal challenges and how you address that as well. So, trying to tie it into real life current events.
And for those who don't know, David Kelly used to be, he still is a rapper, and he's really good. And he performed a lot and did very well in that space, and then decided to become an attorney. And so his story is really compelling and interesting, and I think it resonates with our youth who want to see that, you know, who kind of have those people who they want to be like, you know, in the entertainment industry, but with that connection to the legal industry that could foster a bridge and spark their interest into becoming attorneys. And so this is great to hear, and hopefully we can do other video projects. I would like to see, I'm just gonna throw it out there, I would like to see us do one on Heather.
Well, we already got clearance whenever you guys are ready to not do me, but to do Linda Dagley at Disney, who is my boss's boss and is amazing. And so Disney's ready to do it whenever the bar is ready to do it. So yeah, we hope that will be video number 2.
Yeah. And I think we'll talk about that when, in the work plan. So
awesome.
We may be ready soon.
Okay. All right. So the next item, 7H, it appears there's no update on it, but it's on the agenda. It's the Judicial Council's request for assistance on judicial diversity initiatives. Can we just provide like a general comment about what that's about, Elizabeth?
Sure. So the Judicial Council, well, several years ago when the State Bar kind of set its diversity priorities, in conversation with the Judicial Council really wanted to take the lead in judicial diversity efforts. And so, but because COAF and the State Bar had been involved prior to that, we remain available to them whenever they would like our support. Most recently, COAF members worked with the Judicial Council to update their judicial diversity toolkit, which is now available on their website. So whenever there's opportunities to collaborate with the Judicial Council, we just want to remain open to it. And at the request, we can participate in those activities.
Excellent. Thank you, Elizabeth. All right, so we're moving on now to the liaison reports. And the first report is from the California Lawyers Association. Do we have our liaison from CLA?
I don't see him. He's not on yet. I know he was in court today, so maybe joining us a little later.
Okay, so we'll put that at the end. Hopefully he could join us before our meeting concludes. And so we'll move on to the California Leadership Access Workforce and California law, and that's Pat Lee.
All right, thank you. First of all, for those on COAF who might not be aware, the California Law is a nonprofit that was created a number of years ago, but it has taken the role of assuming all the early education pipeline activities that the State Bar used to perform. So we're now in the business of supporting, administering, and enhancing, expanding all the pipeline efforts from high school, early education, even before high school, all the way up through law school. And the pathway includes our 22 high school law academies, 29 community college partners, and 9 law schools and their counterpart undergraduate programs. Shalak is on the line, and Pepperdine is one of our partners, our partner law schools and undergraduates. I wanted to report today on the 6th Annual Pathways Summit that we're planning, thanks to Judge Esther, Ryan, and Shalak also in being on various planning committees for programming on that conference. And also thanks to the State Bar, because even though the State Bar isn't actively involved in early education, this is the second year the State Bar has provided sponsorships for the summit, and we really appreciate that. For day one of the summit is basically used to provide professional development for the teachers in the high schools, community colleges, undergrad, and so forth, as well as the volunteer advisory council members and members of the community. So this day one is really jam-packed. We looked at all the issues that are facing the teachers, administrators, and students, especially in this pandemic situation. And the first session is a plenary for all the participants to focus on mindfulness and relieving stress in a stressful world. The feedback we get is that there's a great deal of stress at the administrative level, but also with the teachers and in the classroom and with the students. And if you've been involved with students in mentoring and so forth, you've also experienced that level of stress and kind of feeling distanced from each other, as well as the school setting. So we're going to focus on that to try to address the issues and bring people closer together and try to help them focus on how to de-stress in these various situations. The next session will be on focusing on the teaching teams from the community college level on the way up through high school, and it's getting students ready for the workplace. It's teaching teachers and counselors and volunteers on what they need to share with students to prepare them for their pathway, whether it's from high school to community college undergraduate to law school and so forth, so that they're prepared and can look at how to bring in resources, talk to people to support them prior to entering into those systems and becoming more successful as they travel through the pathway. The next session is teaching teams in high schools, and with the high schools, we look more at in terms of enhancing skills to address classroom issues relating to students, getting students to become more involved and so forth, and looking at some of the critical skills that students will need to develop as they move through the pathway. and any key substantive issues that they think that they would need help on in terms of enhancing their lesson plans. And then we have a student track called What I Wish I Knew About College and Law School. And that's going to be led by AJ Howe. He's an admissions person from Santa Clara University. But it's taking input from the feedback from students as they've moved through the pathway and kind of looking backwards on, gee, I wish I had known that before I went to that next level. So it's trying to educate the students beforehand on what to expect so that they can be more prepared as they travel through the pathway. The second day will be focusing on racial equity and justice. Both Judge Esther and Ryan are on this planning committee, and we think we have it down pretty much now. We've been kind of looking around in terms of what the identified speaker panels will be and so forth. And what we've decided upon is that we've invited Brian Stevenson as our keynote, and we've given him a couple of options. In a week or two, his staff will be working with him to look at the requests that have been submitted so far for his participation. And we've offered him to either speak live as a keynote or to submit a pre-recorded video. So we think we might have a better chance with those options, and to give him an idea of what the focus is, who our participants are, so he can address the issues from our perspective. We have also, we didn't want to do a panel because we had decided to invite some pretty high level speakers, and we figured they wouldn't want to just be one of 4 members on a panel. We're going to invite various leaders from the state level, the local level, and community activists to talk about what they've learned about becoming active, how they are able to affect change through policy, involvement in civic engagement, and so forth. And we're going to use a TED Talk format. We're going to invite them when we confirm them. They will be able to provide a 15 to 20-minute TED Talk presentation so that they can focus on what they think is really important, how they got involved in the process, what they see as important in terms of policy making, tips that they can give to the students, faculty and volunteers and so forth, and how they can affect change through civic engagement. So we're inviting, hopefully we think we have a pretty good chance with these invitations. Lorena Gonzalez is the state representative. Michael Tubbs, the immediate past mayor of Stockton. Nathan Mizell is a UC Berkeley student who is also vice chair of the City of Berkeley Police Commission. So we want him to give his input to the students, especially how he got to be so active and taking a leadership role in the Police Commission for one of the more progressive cities. And then Elisa Garza, one of the co-founders of Black Lives Matters. We have some personal contacts with her, and we hope we can get her on, giving her the same option of a live presentation or a recorded, pre-recorded video. And she's also on a book tour promoting her new book called The Purpose of Power, How We Come Together When We Fall Apart. So we figured she could promote what's in that book as well. So those are the people we're targeting for those TED Talks, and we're pretty excited about that program. Day 3 is looking at student participation and student development and how they travel along successfully along the pathway. Our plenary speaker is Latifah Simon. She's a well-known civil rights and racial justice advocate, the director of the Kanadi Foundation, but she also has a lot of leadership positions. She's the chair of the BART, Bay Area Rapid Transit Board. She's on the Cal State University Board of Trustees, and she's been the executive director of the Lawyers Committee for Civil Rights, and is very well known. And we're really excited to have her, and she's confirmed. And Shalak is the moderator of the program that's going to follow that. First of all, she's going to feature some of her Pepperdine students who have a program that they've created for mentoring. And then after that will be a panel of students who have successfully traveled through stages of the pathway to give their feedback on what they've learned, to give their tips to students on how they can be successful in traveling through that pathway as well. And then the final thing is the awards ceremony where Cal Law would give out its awards for organization, high school, and law school. And that's where we will also present the statewide education pipeline award that the State Bar used to present when it did its when it was giving out awards. So we have retained that, and we will be distributing nomination information soon, and we'll send that to Elizabeth so that that can be circulated to all of you and through the State Bar's communications vehicle as well. And that's open to all entities that engage in educational pipeline work, not just California law entities. So those 4 awards will be presented at that session. A couple other highlights. We are partnering with California Lawyers Association to create a speakers bureau for statewide speakers through all the high schools and community colleges, and they will be circulating information from CLA, opening up as will we. And then also, I'm chair of the ABA Standing Committee on Public Education, and we will be convening our annual National Civics Law Academy. That will be March to April of 2021. We'll be doing a virtual format this time, so we'll have 3 cohorts of students, one on the West Coast, East Coast, and in the Midwest. And teachers are being asked to nominate students who are interested in law and government, who have a leadership potential and a commitment to social causes. But we need volunteer attorneys and judges who could be speakers and also who can participate in online conversations with the student cohorts. And we need law student volunteers as mentors. I'll submit all this information to Elizabeth, and she'll be able to send this out to you in more detail. But if any of you are able to volunteer, I know Heather had asked a while ago about volunteer efforts. This is your chance, Heather, and all your colleagues too. So we'll need volunteers, and we're not sure if we can get volunteers for each region. We probably can, but I'm focusing on West Coast because we want to have a really good cross section of people as attorneys, judges, and law students to help volunteer to help support these students. So, and that's it.
Right. Thanks, Pat. That was a lot. You guys are really doing good work over there at California Law. So thank you so much for your leadership and all that you've done. Does anyone have any questions or comments? All right, seeing and hearing none, I'll move along to a Judicial Council report on diversity and inclusion initiatives from Judge Yu.
Pat, that was an amazing report, and you have always been such a treasure. My report's going to be really puny compared to yours, but I'm so impressed with all the things that you continue to do. So I'm happy to provide an update on the diversity and inclusion initiatives from the Judicial Council. Diversity in the branch continues to be a priority, and the Judicial Council continues to highlight the pathways to Judicial Diversity Toolkit, which was previously mentioned by Elizabeth. COVID-19 has provided staff with the opportunities to transition to virtual presentations on judicial diversity. So staff from the Judicial Council and myself made a presentation to the Santa Clara County Superior Court bench in May of 2020. And also the Judicial Council staff made a presentation to the Bar Association leaders throughout the state in October of 2020. Planning is underway for the 2021 Judicial Diversity Summit, as you know, between the California Lawyers Association, CLA, and the Judicial Council. Tentatively, the summit will be held in September of 2021 and will consist of virtual events as well as hopefully in-person events, depending on the status of the pandemic. We're optimistic that incorporating a virtual component to the summit will allow us to reach a larger audience, and we're in the initial stages of planning and will provide updates. Leading up to the events, we'll be highlighting the disparity between the Latinx population and representation on the bench through virtual presentations throughout the state in conjunction with CLA and local bar associations. Currently, let's see, got to scroll down from my notes. Currently, joint presentations on pathways to the bench with CLA will be held statewide in February 2021, and with the San Bernardino County Bar Association and with CLA in April 2021. And then finally, the Judicial Council has been working with Jenny to provide training on judicial diversity, bias, and the effects of decision-making. And the first training was held in August of 2020, and a future training is scheduled for next month in January 2021. And the Judicial Council and Jenny will be developing additional levels of training for the commissioners during their 3-year term. So that concludes my report, and I'm happy to answer any questions or take any comments.
Thank you, Judge Yu. Does anyone have any questions or comments? All right. You might hear my assistant in the background. Okay. All right. So, and I'm not going to apologize for that. I was advised not to. Okay. So I think we're finished because I don't see Kenneth Wong on here. Do you see him, Elizabeth?
I don't think he's been able to join, but maybe we can circle back when he is able to join.
Okay. All right. So let's go ahead and move on to the next item. I see here it's the discussion and approval of the 2021 work plan.
And our first item is to have a presentation on law school loan repayment by Kristen and Heather. So I'll share the screen with your PowerPoint. Is that okay?
Please, thank you. So this is something that we're hoping, Heather and I are hoping we can add to COAF's work plan. And hopefully Elizabeth can share the slide deck with folks later because there's a lot of information in here. And I will try to do my best to not read it all to you, but give you really the highlights of this. This is really, this whole addition to our work plan really came out of the last meeting, both from hearing about the State Bar's annual diversity report card and then talking about the retention issues in law school, and then really thinking about how much debt students are leaving law school with. So if you can go to the next slide, Elizabeth. So we're talking about public service. This is the definition that's used by the federal government. We're talking about public service, loan forgiveness, and loan repayment. Public service is defined by the federal government, at least, as government institutions and nonprofits or volunteer work through AmeriCorps or the Peace Corps. Loan repayment is a general overall umbrella term that's used by law schools and states, the ABA, to talk about the loan repayment programs that are available to law school graduates to help them make their student loan, meet their student loan obligations when they're working in the public sector. As we'll talk about in a little bit later, most of the aid that's being given right now is in the form of a forgivable loan, which we'll talk about why that's perhaps not a great idea. But I want to give everyone a little bit of background about where we're coming from and why we think this is important. You can flip for me, Elizabeth. So these are snapshots that are just taken from the State Bar's annual diversity report card, from the first report card that came out. I think it was presented at the last COAF meeting, but as a reminder for folks, and because I think these graphics are really important, we see that 55% of the government attorneys are women, yet women comprise only 42% of all attorneys in California. So women are overrepresented in government work. And the same trend follows for attorneys of color. As you can see from the chart, in fact, of the government sector, only 29% are white men. And women of color are again overrepresented in government work. 23% being in government sector, and as you'll see in the next slide, only 16% of attorneys in California are in fact women of color. The same trend follows for the nonprofit sector. Again, women and women of color are overly represented in these sectors. And I give all of this background, we give all this background because these are the areas in which, of course, are earning the lowest salaries in the legal profession. And so what you see are women and people of color overrepresented here. And then, of course, in California, making the lowest salary as attorneys. If you want to flip for me, thanks. So before we talk about the loan repayment itself, I just wanted to give folks some statistics and give everybody a sense of where we're coming from. The cost of law school has outpaced inflation and legal salaries. And I think the ABA and US News and World Report took a survey, and only 23% of law school graduates in the last 10 years said their education was worth it. And when you see what law school debt looks like, you'll know why. Law school enrollment is actually at its lowest number in 20 years. And in large part, that is because of the debt that students are carrying when they leave law school and when they're coming in. I think it's important to remember that lots of students going into law school are already carrying debt. And that debt, again, disproportionately impacts students of color. As you can see from some of the statistics, nearly 87% of Black students, 65% of Latinx students are borrowing to attend four-year public universities, as opposed to 60% of their white counterparts. So they're all, people of color, students of color are already coming in with greater loans going even into law school. I think that the law school debt is only part of the problem. The other problem is the wage gap that heavily impacts loan repayment. While overall women earn 77 cents for every dollar a man earns, that number is much lower for women of color. In California, Black women earn 59 cents for every dollar that a man earns. What that means when it comes to loan repayment is it's going to take women and women of color many, many, many more years to pay off student loans than it will take men, especially white men. And if you flip the slide for me, I want to talk a little bit about the law school debt. So again, I'm one of those people who think that charts really paint a beautiful picture. And here is what the increase in law school debt looks like since 1999. Right now, the average law graduate leaves with $160,000 in cumulative debt. That again, and I want to point out that's the average. That means that there are plenty of people who are leaving law school with a lot more debt. In fact, 45% of those students entered law school with debt. As one of those people who entered law school with undergraduate debt, I can tell you that that it's an additional burden that goes on top of the whole playing field. The other thing that I think is important for folks to think about when we're talking about law school debt is it's not like undergraduate debt. Law school debt, graduate school loan debt starts accruing interest immediately. So you may borrow $120,000 in your 3 years of law school, but by the time you graduate, it's going to have accumulated interest. You're going to owe considerably more. And in fact, a 2020 ABA study found that of those who had graduated before 2014 and thus had been practicing for 5 or 6 years, 45% of them owed more in student loans in 2020 than they did when they graduated law school in 2014. 45% owed more after working for 6 years. And again, I don't think, this is one of those issues that I'm really passionate about, and Heather knows because we've talked about it a lot. We are not going to get a diverse legal profession if we can't fix this problem. And we can't ask people with all good conscience to go into a profession knowing that 45% of them 5 years later will owe more money. So I think this is a really important issue, and that's why I'm sort of talking passionately about it. If you flip to the next slide, I want to just give folks a sense of what it looks like for California, since we are here in California. I included Pepperdine on there. I'm sorry, Shellac. I knew you'd be here. I thought you'd be here. but Pepperdine is obviously, you know, in the middle. This is not every one of the ABA accredited law schools. That slide was too hard to put together, but I wanted to give folks a sense of where we are. Golden Gate University, nearly 90% of those students are graduating with debt, and the average debt's $142,000. This is a 2019 numbers. Southwestern Law School, over $200,000. That's the average indebtedness for a graduating law school is $200,000. So that means there are a number of students who owe considerably more than that. Stanford is, you know, this is, the table goes down. Stanford, it goes down with percent who are in debt. And I have an exhaustive list if everybody wants, if they want to see it, where your law school fit, if you're a California law graduate and you want to see where your law school is. But the point I'm trying to make in this slide is that, yeah, these are California graduates with a California cost of living. So you're taking into account that everyone has to live and work in California, which is, as we all know, not an easy state to live and work in, especially if you're going to be in the public sector.
Kristen,
yeah.
Michael has a question, if you don't mind.
Yes. Yeah.
Sorry to interrupt you. You
No.
maybe these numbers are, I mean, I wish I could say they were surprising, but they're not. They're familiar. Do you have any idea what the breakdown is between government loans versus private loans when it comes to these numbers?
So what I can tell you is, and there'll actually be a slide in a minute that sort of breaks it down a little bit. But what I can tell you is that students of color disproportionately tend to the private loans over white students, and part of that is because there's a cap on how much you can take out in public loans, and so if you need more than what the public you can get in the federally public subsidized loans, and you have to go to a private sector, that tends to again disproportionately impact students of color. And so I don't have the breakdown for that specifically, but I can tell you that the numbers skew exactly as you would imagine. And in a minute, we'll talk about what it looks like to try and pay back a private loan. It's hard enough to pay back public sector loan, the public federally subsidized, but a private loan is considerably harder. If you want to. Yeah, yes.
Yeah, so this is Donna. I apologize. I wasn't here at the beginning of your presentation, so you may have said this already. Yes. But I do want to make sure that sort of folks understand that your numbers relate to those students who are attending ABA law schools.
Yes.
And that California accredited law schools and registered law schools have a significantly lower, at least the registered do, have a significantly lower annual cost, a somewhat lower annual cost for the California accredited law schools, and so the debt amounts are lower. And I don't know if you've got sort of how those break down by race as well.
So so we certainly have. Yes, you're absolutely right, Donna. And I think I said that they were ABA accredited law schools. In California, we do have a number of registered and accredited law schools, and in the debt for those students does tend to skew a little bit lower, in part because some of those programs are part-time, and so people can work, which for those of you who went to an ABA school know it's a little more difficult to hold a job down while also going to law school. And so those part-time programs do allow folks to, and that data is a lot harder to pull because, most of the data is collected by the ABA or US News and World Report or those kinds of entities, and they're not looking at our, at California registered and accredited schools. And I don't know that if the state bar has those numbers. I didn't see them anywhere, Donna, but maybe I know that the numbers for diversity, but I don't know that we have loan debt numbers for those schools.
And I want to be very careful about messaging in any kind of way to minority students that they should funnel into non-ABA law schools, because that might be the least expensive route. Because then you will find, I think that would create a disproportionate amount of diverse law students feeling like they only can go to a non-ABA accredited school. So I just want us to be careful about that message.
No, and I think you're right. And actually, I'll digress briefly that Elizabeth and I went to, saw a presentation that Justice Liu did on who's going to law school. And one of the slides that he presented was the tiers of law school, the 6 tiers of ABA accredited law schools. And you know, what he showed on his slide, and hopefully we'll be able to have him come and maybe present to us at a future COAF meeting. What he found is that obviously, you know, not surprisingly, that the tier 4, 5, and 6 ABA accredited schools had a, you know, higher minority enrollment than tiers 1, 2, and 3. And so I think you're right, Heather. We don't necessarily want to be saying to students of color, you know, go to these other schools, you know, but I don't know the debt numbers for those. So what we have is ABA stuff.
Can I just ask a question maybe? And I know in an earlier slide, Kristen, you and Heather had referenced the wage gap numbers. I'm wondering if in future, or maybe we'll talk about this in planning the work plan for next year, there's some comparison and deeper dives that can be done in comparing these loans at graduation to career outcomes, and where these students who take these higher loans may find themselves employed, and whether or not those employment. Did I jump your gun?
a little bit. No, it's fine. You can jump. It's fine.
Only because I was thinking as we talk about like law school interventions and so on, I think this is the type of thing, I can speak certainly for our dean. I know he's very, very concerned about like return on investment, but this is the type of thing that would be very compelling to at least the ABA accredited deans to hear from the state bar that like, we have these numbers and you need to up your employment outcomes to match your student loan numbers. I think that would be a really compelling call to action.
Yeah. And so I have a little bit of that, and it's mostly ABA stuff, and I'll show that in a slide in just one second. And I appreciate you all being super engaged in this. You know, Heather and I are super passionate about it. And so I appreciate all the questions and comments on this, because it is really important. And thank you, Sal, for providing the Latina pay gap.
Before you move on, I just wanted to ask Donna if you could answer the question of whether we have the loan debt loan data for California accredited and registered schools.
So I don't think so. I know we get annual reports from the accredited law schools and the registered law schools. We've been working with them to, as you all know, to get improved data on diversity, and so we can be looking at attrition data, and we can match what we know about the ABA schools with those schools. I don't believe we have loan debt information, but I certainly know where to ask, and so I will check into that and see if we have any information on that.
Thanks, Donna. I actually took a look at a handful of that because I had worked on the CS bars. And so I took a look at a couple of the accredited and registered law school websites to see if I could find that information on their website. And it didn't appear to be available on their website. Perhaps not surprisingly, they're not sharing. Nobody's really sharing the average debt amount easily. But it would be great if we could get those numbers. Okay. I know there's other things on the agenda, so I don't want to take other time. But so again, student loans, we know, take your disproportionate toll on students of color, and this is true of lawyers of color. if you look, 10.7% of Hispanic, Latinx, 13.5 of Black lawyers owe under $100,000 as compared to 26% of their white counterparts. So, and if you look in the range over $200,000, I'm guessing no one here will be surprised that students of color, lawyers of color owe more than $200,000 at a much higher rate than their white counterparts. Asian lawyer, 40% of Asian lawyers, in fact, owe over $200,000 in student loans. And that number is below 25% for white lawyers. So again, we have, the huge student loan debt taking its toll on lawyers of color. If you flip, Elizabeth?
Yep.
So taking what we know about where most lawyers of color are practicing, most women and most lawyers of color are practicing in that public sector, knowing that they are leaving law school with more loans. These are the very real public sector salary information. $56,000 is the average starting salary for a public sector attorney nationwide. In California, 42% of California nonprofit attorneys earn less than $56,000 a year, 42%. The starting salary for an attorney one with the state of California, which is an entry-level government job, $67,000. The average starting salary in the private sector is $91,000. So a large gap there. If you will be so kind, Elizabeth, thank you. So Michael, here's a little bit about the private sector loans. So this is the reality of loan repayment. The Federal Consumer Finance Protection Bureau suggests that that students pay back approximately 10% of their gross salary to their student loans every month. Realistically, however, if you are a public sector attorney making $56,900, which is the average salary, and you pay 10% of your salary to your student loans, you will never, ever be out of debt. And this assumes this is the 5.3 is the public loan amount. If you get a private loan, which again is something that impacts more students of color, that is at 10% right now. Even if you paid back 20% of your salary every month, you would still never get out of student loan debt. And the numbers are actually not that, the numbers are not that great for private sector attorneys either. It really is impossible if you pay the 10% to ever get out of debt. And we talk about a percentage, but even if you're paying 20% of your salary, which is nearly $1,000, that's a lot of money in California to put towards your student loans. And it's still going to take you nearly 26 years to pay off your student loan debt. And I want to put this in perspective for folks because I think it's important. I have been out of law school for 25 years. And I have been in the public sector for the entire 25 years, the last 13 of which I have been on the bench. I am still paying off my student loans. And I am over 50 and I am still paying off my student loans. And I will be probably for the next several years. I am fortunate to, to be able to afford to live here, but it's a reality of students who graduated 25 years ago, which is when I graduated. If I were to graduate now, I would never be able to pay off my student loans. And so, I want to put it in perspective because I did graduate 25 years ago when law school was only, you know, I went to Hastings and law school was $3,000 a semester when I was there. And I'm still paying off my student loans. So it's a real thing if you're a public sector attorney. And this actually, and the other statistic that I want to sort of throw out, and this goes to your question, Shalak, is that the ABA did a study in 2020 of law school graduates. 40% of the law school graduates said, with student loan debt, said, I took a job that paid more over the job I wanted to take because I could not pay my student loans. And so, you know, to answer your question, you know, the ABA has been looking at it, and, you know, they did a study, and overall 40% of them said, of graduates said, I took a job I didn't want because I had to, which I think, you know, is sad on a variety of levels. Yeah.
I have nearly instantaneous feedback for you.
Yes.
We do not have information on the debt load for the accredited schools and the registered schools. The schools are required to report if they offer federal loans, private loans, or veterans benefits, but not the total amount of the debt load. And I do want to be clear, I was not sort of suggesting any sort of shuttling of anyone into a particular kind of school, just a matter of understanding for California law graduates, the numbers are slightly less than that because some of the schools cost less. But the majority of California law students are going to the ABA schools, you know, statistics wise. So the numbers are slightly less, and that was all I was trying to point out there.
Thank you, Donna. And maybe we can add, you know, to COA's work plan, figuring out a way to get that information from the other schools. Okay, so if you flip, Elizabeth, so one of the ways in which both states and law schools have tried to address the staggering amount of debt that law students are leaving with, and those students who want to work in public sector and nonprofits, is that they have created these loan repayment assistance programs, which LRAP is what they're called. There are 23 states with an LRAP program, over 100 law schools. And while they are not ideal, they do have some benefits. If you flip, Elizabeth, we can talk about those benefits. So a couple of the benefits, or maybe the only real benefits to these programs, are that they are available to recent law school graduates. You don't need to be working in the public sector for a certain amount of time before you can get access to these. In fact, most permit only recent graduates to apply. So if you're more than, say, 3 or 4 or 5 years out of law school, your law school or your state is less likely to allow you to even apply. It usually is reserved for recent law school graduates. There are usually, if you live in a state, one of the 23 states that has an LRAP program, you are able to apply both to your law school's LRAP program and to the state. So there is a multiple funding sources available to you if you are in one of those states. If you flip the slide, Elizabeth, there are unfortunately more drawbacks right now to these LRAP programs than there are real benefits. First, as you can see, the amounts that are awarded are usually very small, and they usually max out at about $5,000, which is well below what your student loan payments would be. And those are maximum awards. You know, most law schools in states give out somewhere in the neighborhood of $1,000 to students. Not all public service jobs are eligible. It depends on your state or your law school. The state of New York has a program, but they only give money to district attorney and public defenders. All other government and nonprofit attorneys are left out of that program. In some states, it's only available to legal aid attorneys and not to other nonprofit or government attorneys. So who is eligible also varies. The number of recipients is usually very small. The state of Illinois has a program that is run in out of the Bar Association in Chicago, and it grants 20 awards a year. So if you can imagine the number of public sector attorneys in Illinois, only 20 people a year are getting any money from these programs. The state of Indiana gives out 2 awards a year. So again, it is really hit or miss about who can even get some money from these programs. If you flip one more time, Elizabeth. There are limited years of participation, usually 3 to 5 years is the most you can participate in a state or law school program, and most have a salary cap. The salary cap for most programs right now is about $60,000. This is true for states and law schools, which means that if you make $65,000 or $67,000, which is the starting salary for a government attorney in California, you won't be eligible for the program. Most require yearly reapplication, which means you're not guaranteed to get money the next year. If any of you have ever applied for one of these, it is not a small application process or a small application packet. It usually requires letters from your employer and proof you've been paying your loans, letters showing that you've been in public service, or a public interest job for a certain amount of time. And lastly, they are in fact mostly forgivable loans, which means that you're getting a forgivable loan. If you default on that loan, it becomes more debt on top of the debt you already owe. So if you were to be unemployed or to leave your public sector job for some reason, you would have to pay back this loan from whatever entity you got it from with interest. So if we flip one more time, I know folks are going to ask if California has a program. And in 2001, the legislature authorized a public interest attorney loan repayment program. For 15 or so years, the program existed on paper only, and it was unfunded. In 2015, there was a bill passed that allowed unclaimed IOLTA funds, and Elizabeth can explain perhaps a little better than I what those IOLTA funds are as a funding source for LRAP. And do you want to jump in, Elizabeth?
So the unclaimed IOLTA funds, so as you know, attorneys must keep interest on lawyer trust accounts for any funds received from their clients. Oftentimes when an attorney closes their practice, they need to return all the funds to their clients. Sometimes they aren't able to find those attorneys. And so those funds are unclaimed, and right now they become escheated funds, and they go back to the state of California. So I believe this bill was authorized to take those funds to fund the LRAP program.
Right, and it's my understanding that well, even assuming that was a large amount of money, which I'm sure it is not, that has not actually happened. So there,
yeah, there's currently not a mechanism to transfer those funds to, and Kristen, I think you've told me this before, to the organization that runs the LRAP program.
Right. And in fact, and I believe it is it's the California Education folks, and there's no information on the state's website about this program. So if you tried to find it, you would not be able to. It exists sort of in paper form only, but and it is unfunded. And perhaps that's one of the areas that you'll see on a slide later about things we might be able to do. If you flip one more slide for me. So there is, I wanted to highlight a loan repayment assistance program that actually works. The National Health Service Corps model actually works, and And right now it's a federally funded program. If you work as a doctor, dentist, nurse, other health professional in what is considered an underserved area, the National Health Service will give you loan repayment assistance. Each year, you get $25,000. It's a 2-year commitment initially, so you receive $50,000 at the $25,000 first year, 25 the second year. And that money goes directly to your student loans. In fact, you have to show that you paid your loan servicer. The participants in that program earn a competitive salary. They earn what others health professionals earn in that area. They don't have to earn under a certain amount. There is no program limit. You can participate and continue to participate in the program until your loans are paid off. And you receive preferential treatment in the reapplication process if you want to continue to participate in the program. And there are somewhere in the neighborhood of $1,800 to $2,000 award ease every year. So it's not a limited number of people. And again, as a personal anecdote, my brother went to medical school 6 years after I graduated from law school. After 5 years in this program, my brother's student loans were paid off. And, you know, as I said earlier, I'm still paying mine off. So the program does work. And my brother served in at UC Davis Medical Center. That was the underserved area that he worked in. It was Yolo County. You know, there are programs out there that work and work a lot better for some professions than for the legal profession.
And that, I just want to add, Kristen, that this model is really well funded. There's foundation funding for it. And there is funding that comes out of you know, your medical license fee, your social work license fee that goes towards this. And that's why it's been so successful. Just, you know,
Yes.
for additional background.
Right. Thank you. I appreciate that. If you could actually, so as many of you may or may not know, there in October of 2017, the federal government rolled out a public loan forgiveness program. And it applies not only to public sector attorneys, but to other professions as well. You have to have worked in public service for 10 years before applying to the program. You have to work for the government or a nonprofit, or in the volunteer corps again, you're full-time. Only federal direct loans qualify for this, so the private loans would not, because you can't consolidate your private loans under a federal program. So this only applies if you had public loans. The direct loans that are the ones you start with when you're getting student loans. And you have to have paid your loans through an income-driven repayment plan. So the program was announced in October of 2007, and then started receiving applications in October of 2017. If you scroll to the next slide, 200,000 people so far have applied for this program. It's actually more than 99% have been rejected. By all accounts, the program is a complete, disaster and failure. And very few people have had their loans forgiven in the 3 years that this program has been going on. The program has been fraught with problems from the beginning. Most applicants don't know why they're rejected. They don't know what their appeal rights are. And the eligibility factors for the program make it very difficult for most people to meet the program. And again, as the last personal anecdote I will share, I am one of the 99% of the people who applied and were rejected, even though I've been working in the public sector for 25 years. When I graduated from law school, there was no such thing as an income-driven repayment program. Your loans were paid out, you either paid them off on a 15-year or 30-year basis, and you chose one of those things at the time. And so for 20 years, I paid my loans that way. Well, if you didn't pay on an income-driven repayment plan, you can't apply for the program. You're not eligible to have your loans forgiven. So even if that program didn't exist when you started paying your student loans, it makes no difference. You will still be rejected. And so, in fact, I don't know anyone who has had their loans forgiven through this program. And I know obviously a lot of public sector attorneys and judges. And I don't know anybody who's had success in this program. So while there is a federal loan forgiveness program out there, it simply isn't working. And so this is where I think that COAF and the State Bar can really do some work. And if you flip, so Heather and I have spent some time sort of trying to reimagine what we can do in California to work on this issue. And one of the things that we talked about is getting private financial institutions involved as part of foundation work for get an LRAP program, but really as part of their DEI initiatives. We know that the student loan burden really disproportionately impacts women and especially lawyers of color. And so this seems to be an area in which we can reach out to financial institutions and say, what can you do here to help us bridge this gap? What can we do to be helping these these lawyers of color, these people who are working in public interest really be able to stay in that area of work rather than having to choose a job that they don't want. And also, what can we do to really reduce the debt burden for all law school graduates? So, we've really tried to reimagine it from two different ways, both trying to fix the state-sponsored LRAP, which we talked about really exists only on paper, but then also reaching out to private financial institutions and doing something more. And what that something more is something that, we haven't fully envisioned yet, but, the State Bar already has relationships with the financial institutions because they are collecting all of this other information and in some cases escheated funds. So, I think this is an opportunity for COAF to really make a difference and to move the needle on this issue. Because if we don't move the needle on this issue, we're going to have a hard time actually diversifying this profession. We're going to have a hard time convincing people to stay in it, to go in it in the first place. And we have to, be honest about what it means when you graduate from law school. We have to be honest with these with students. And I'm afraid that, what honesty looks like right now might really impact who goes to law school in the future. And that means that we're impacting who sits on the bench in the future and who holds political office and who's in corporate America and a lot of other, areas. And I think we have a chance right now. And, I know that Heather feels strongly about this as well, that this is really a time, where we are in society. This is really a time where we can push, DEI initiatives that will make a difference, especially with private financial institutions.
Novella has a question.
Yes, Novella.
Yeah, thanks to Kristen and Heather for putting this together. It's really informative, and I'm glad we have two people who are just really passionate about this issue looking into it. I was curious if you guys have looked into ways to reduce law student debt that isn't a loan repayment program. So an example I'm thinking of is when I started law school, Harvard had a program where if you committed to doing 5 years of public service, then they waived your 3rd year of tuition. And I feel like that approach was good because it reduced that like huge number that you graduate with owing. And it also ended up encouraging a greater percentage of my class to go into public service. I think so much so that they were like, oh shoot, we don't have enough money to do this. And so it was just like a 1-year pilot program. But then it also, I think it just makes it easier from like an incentive perspective, and especially for people who are risk averse, if you can sort of move to the public interest track, knowing that you don't have to like have that big of a, I owe this much number, and it sort of gives you a little bit more peace of mind about what you'll ultimately have to pay back. And then if you didn't do the 5 years, they would like prorate it and you would pay back the rest, but they also didn't penalize you if you had like gaps in employment. But I'm not sure if that would be viable for like California law schools and how they're funded.
So I think that's a good point that we could, you know, perhaps rename it like tuition reduction in some kind of way, and it could encompass loan repayment or some other creative way to do it. I think I don't care how they formulate it. I just wanted to get it done. And so I think reaching out to financial institutions and putting it on their radar and letting them brainstorm about what they feel most comfortable with, whether that's creating their own loan forgiveness program, whether it's funding, you know, an LRAP program, whether it's funding an endowment at law schools that allow for scholarships or grants. So on the front end, you know, find out that if you want to go down that path, there's an option for you. I think we're very flexible in how the people with the money want to structure it, but we do feel very passionate about striking while the iron is hot. And these, you know, that companies, corporations, and financial institutions are thinking about better ways that they can impact you know, students and the profession, and really taking advantage of putting these thoughts in front of them so they could be brainstorming and structuring something accordingly. And I mean, Judge Kristen did all the work on this. She gets all the kudos for the heavy lift on it, but I became passionate about this listening to her talk about it at the last meeting. Like, she transferred her passion to me because I was in shock by the stories she just shared with all of you. I couldn't imagine that you could be practicing in the public sector for 25 years and still have debt. And one of the things I wanted to say is, I think, and also to, I think, Donna and Elizabeth's points earlier, is there are several misconceptions out there, right? So I think the public in general thinks lawyers make all kind of money. Everybody that goes to law school goes to a law firm or goes to some big corporation. And so you don't have a lot of empathy for people having all this debt because you assume everyone is making a bunch of money. So that's a misconception at the public level. And then even as a lawyer who has not practiced in the public sector, I always thought all LRAP plans were, you know, similarly situated, right? So when Judge Kristen and I were talking about this, I was like, but all my friends who were going into teaching would talk about like the programs where for every year that you taught in a, you know, underprivileged area, you got a year of your loans, you know, reduced or forgiven. And so if you did that for 4 years, you basically got all of your cut. And she was like, no, it's not like that at all, which is why we wanted to show the health, you know, loan repayment program as an example of one that is doing it right. So certainly there are models out there, and we're just not utilizing the right models or getting the right funding for that. But it feels hypocritical to me. What I am also really passionate about is pipelining. And so it feels hypocritical to me for us to put these brochures out that say, you want to be a lawyer, and have Patricia and Cal Law do these amazing programs, and then throw these students into a situation where they get out and they are, you know, heavily indebted. I have been practicing for 23 years. I'm one of the people on that 30-year program, Judge Kristen. I still have 7 years left to pay it off, and I am in corporate America. And so I just want to make sure when I'm going out and talking to young people, most of the young people I'm talking to that are diverse, that even at the ABA schools, they really want to work in the public sector. That's where they're very passionate about it. I'm fighting against that to convince them to come to my side of the practice. And I would love to be able to tell them that the decisions they're making, you know, we encourage because some new programs have been put in place. So we just really thought this is a place where we could leverage this group to help influence the right financial parties to really think about where they could be putting their money and planting their money into the community.
Yeah. Can I just?
Sarah had a comment.
Okay.
Yeah, and it wasn't really a question. I was just going to say that was a really fantastic presentation that you, Heather, and Kristen and Elizabeth put together. It was really excellent, really eye-opening, very sobering. And I was going to sort of ask you all what you thought sort of the next steps might be.
We have a next step slide.
Oh, sorry. Hold on.
That's okay. We can talk about the next steps. We don't need the slide. I think that, you know, like Heather said, I think that we are open to how, you're going to put the next step slide on there. Okay. There's one more slide, I think, actually. There you go. I think we're open. I mean, you know, we were really brainstorming about this from the last meeting to this one, and sort of putting this presentation together and doing sort of the research on it. You know, there are examples of programs that are working. And so I think it makes sense to look at what's working. I think it does make sense to look at, you know, things like Novella was talking about, although it sounds like, you know, at Harvard, it only worked, you know, for 1 year, but it was an important year for the people that it worked for, right? I think that we're open to a number of things. I think I do think that we can. I think there is a way to meet and I've, you know, been sort of talking to my accounting, more business-like friends, and, you know, and Sal can probably weigh in on this too, but I think that there are ways that we can make loan forgiveness and loan repayment assistance with private financial institutions. I think we can incentivize them in a lot of ways, both from the, you know, DEI goodwill perspective, and capitalize on you know, folks' desire to be seen as promoting diversity, equity, inclusion across the board, including in the legal profession. And I also think that, you know, there are ways to make financially advantageous for these institutions to, you know, give to programs and then find a way for them to, you know, get a tax deduction from that. I think there are ways that we can probably reach out to the Student Aid Commission, or maybe even move California's LRAP program to the state bar. Most states run their LRAP programs out of state bars, or out of, you know, larger local bars. And I couldn't find any that were running it out of a Student Aid Commission, but that is apparently where ours is currently housed anyway. So I think that I know Heather and I are open to, anything and everything, but I think there are ways that we can make both loan forgiveness and loan repayment work better than we're doing it. And that's why we wanted to be on COAF's work plan. And that's why we're sort of throwing it out to this brilliant group of people, because we want to hear what other people think.
And I just want to note that that the Legal Services Trust Fund Commission has been talking about, has added to their work plan recruitment and retention and focusing on LRAP. So I do think it's a good opportunity to coordinate with them. And the Access Commission, the California Access Justice Commission, is also looking at recruitment, retention, and LRAP. So I think lots of great minds are thinking alike right now, especially in this in this timing. And so I think there's lots of opportunity. It's just really kind of coming together to make sure we're all kind of walking down the path together.
I'd say this is sort of unfortunate timing. in good timing in the way Elizabeth's talking about, sort of for us all sort of coalescing on a similar perspective. Unfortunate timing in that, you know, one of the ideas that was bouncing around some of our heads for a little bit was, you know, California gets through the state bar, we fund legal services programs through the Interest and Lawyers Trust Fund, Interest and Lawyers Trust accounts, and also we collect a Justice Gap, voluntary donations through the Justice Gap Fund, and those donations have totaled about $1 million a year. And so, you know, one of the ideas that had been floating around was, well, you know what, we're doing pretty well with the IOLTA funds, with the interest rates having been going up as much as they had been. You know, maybe there would be an opportunity to discuss with the relevant parties using that $1 million from the Justice Gap Fund to fund something like LRAP, exactly like we were talking about here. And then with the pandemic, interest rates plummeted. We, you know, are between 2020 and 2021, the amount of IOLTA funding that's going to legal services programs is being cut in half. And so suddenly that, you know, $1 million is really important for the legal services programs to be able to continue to count on that. And so so in that sense, there's sort of bad timing. But I think together, I mean, I love the idea of partnering between COAF, the Legal Services Trust Fund Commission, and the Access Commission on sort of coming up with some good ideas. And I did want to steal from everybody else who said, Kristen and Heather, this is really fantastic presentation, and really got people thinking quite a lot. And I love your passion for it. And I think it really is sort of creating an opportunity for COAF, you know, as we look at our work plan and know that we are looking at ways to improve retention. That is part of the work plan, that this would be a really good element to really focus some of those efforts.
I think that just gave me another idea. So, you know, when we were doing the report card and I was like, we have to put it in bold and red at the time that you're paying your fees. Like, we need this information for the report card. And I have been on the board of the PTA at my kids' school for years. And a lot of what is funded at that school is also paid by the parents, but I think a lot of parents don't know. So we started marketing as part of that fundraiser, like, do you know your contribution, you know, your donation to this fundraiser paid for the computer lab, the, you know, music teacher, I mean, I think parents just really had no idea. They thought those were things that were paid for by the district. And I think maybe there's an opportunity from a marketing standpoint too, while we parallel path multiple ways to fund this fund, with the next round, or, you know, whatever is the appropriate timing of collection of bar dues, to say, like, if you contribute to these funds, these are the kinds of things it would help. Because I still think people are clicking through really fast and they're just trying to get their, you know, payment in, and they're not thinking about, if you heard Kristen's story, when you, like, I would, you know, definitely increase my contribution. So finding a way to really make the human connection for people of where that money is going and who it helps, I think could be helpful. It's just one path while we're doing everything else.
Yeah, just to echo in, yeah, Heather, perfect statements, perfect comments, and just to echo everybody's praise for you and Kristen, and the really just the enormous amount of work that went into this. I mean, so comprehensive, so thorough. Thank you for that. It enlightened me in a lot of ways. And I threw that pay gap number out to you, Judge, because I was working on it separately with my group at Equinix and the group that we started, Hint to Connect, talking about things like that and the pay disparity. But you know, it's something, somebody else made a comment about how, I think you said it right, that the LRAP is not part of the state bar. It's part of another organization that's not related to the state bar. And I think that, you know, this kind of calls out our mission. And if we're really serious, and I know we're serious about COAF really making an impactful difference in the state, to really change from today to maybe 10 years out the number of diverse attorneys and judges, then we have to make, I think, part of the thread of what we're doing and everything we're creating here is how much can we influence people to understand that it makes pragmatic sense to put everything under one roof. And this is perfectly situated for one that should be under the roof of COAF, right? It should be in our house because of the way it affects women, the way it affects minorities, but also the way it affects law students in general. And we just, you and I spent all this time working on this great brochure, and it's not going to go anywhere in the inner cities if they're like, well, screw it, I can't, I can't afford it. And then we say, yeah, you're right, you can't, because we also know this. So I think to create this collection of efforts and endeavors under the one umbrella of COAF would be smart for us, especially this one. And to Heather's point, I know every time I fill out my state bar and who do you want to give to? I don't ever see the LRAP on there. That would be something that if lawyers said, well, if I have to give any extra, like $1 extra, I'd rather give it to the LRAP to one of the committees or to something else. That would be an opportunity there. But it kind of harkens back to a conversation I had really early on this COAF when I asked the question, like something like an LSAT versus the bar. The LSAT community is not part of the bar community. So we have people deciding who gets to go into law school, for lack of a better term, versus the people who decide who gets to be lawyers, and they're never talking to each other. So that's, again, another disparity that adversely impacts a lot of minorities, a lot of women and minorities. So another opportunity, like LRAP, another opportunity to say, what are we doing about that? How much influence do we have to get these organizations, these endeavors to be under the COAF umbrella? I'm not trying to say take over the world, but in order for us to be supremely successful, I think we do have to start having that kind of a mindset. But this is a great one to start with, and really such an important one. And if you can influence the state bar, put that on the state bar renewals every year, where you can donate to an LRAP fund, I think you'd have a lot of lawyers who would understand your plight, Kristen, as many others, and often give to that. That would be a great use of our money.
Michael has a comment.
So I'll first just say, like everybody else, thank you, thank you, thank you. This has really been interesting and fantastic. I really appreciate the focus on coming up with new programs on the back end and partnering with private companies and banking institutions to take advantage of the momentum in the space right now. But I want to sort of second one thing that you said, Heather, about the importance of education around folks who are thinking about going into law school, or who are in undergrad, or maybe even earlier, about what it means to be an attorney, because I think it's a very, like you said, it's a really common perception. I can be an attorney and make a whole bunch of money. And they also at the same time are thinking, I can be an attorney and change the world because we have these great materials that are telling them that. And that, I think, if we're doing that type of education, we do need to be doing both types of education. And there are opportunities there too, I think, to help folks figure out how are they going to tackle this amount of debt, whether it's going to a lower ranked law school that is offering them more money, or whether doing something as simple as saying to one, I got a financial aid package offer at this other school, will you match it? I've talked with students who never did that just because they didn't realize that they could. And so I think that is one avenue that we can explore to tackle it on the front end and on the back end. But kudos to you both on really raising this as an issue. And I'm sure that we could find all sorts of different areas of our working group work plan where we can plug this in, and we should be. So thank you.
And Shalak has a comment.
Yeah, I was just going to sort of second what Michael said, and it's probably because of my current role, but also just even thinking about the law school retention survey that was just sent out. And I know that an attrition factor, along with maybe academics, is the cost of schooling, right? And so I think this is a space that's ripe for, to whatever extent COAF has in the work plan or anything else, anything to do with the law schools, this is a real space to ask the law schools to partner with the state bar on how you're keeping people in law school. Part of it is the funding, and directly tied to it is more, at least I know certainly at Pepperdine, anecdotally from other schools and conversations, more students of color find themselves having to take non-legally related work to get through law school, to avoid taking out, as Kristen and Heather pointed out in that amazing presentation, more private loans for things like cost of living, and many are also those who may provide support to their extended families or immediate families if they're first generation, et cetera, right? And so I think this is an issue of attrition and academic performance for the law schools, which goes into other areas of the work plan. Because if students don't have those financial concerns, they tend to do better. If they're not working outside of the classroom, they, or something legally related, they tend to do better. They have time for networking and all the things we know can make you really successful outside of your grades. So I say all that to say that I really encourage and hope that we'll find ways to overlap some of that. As Sal was saying, with the people who make decisions that end up causing the problems for this group down the road, to have those conversations about what recruitment looks like, about what financial aid look like, about what, a lot of the law schools now are doing their own pipeline programs. But I also know, and I can use us as an example, part of our naming gift from Rick Caruso was directly about providing support to students who wanted to go into public interest careers and could not afford it, right? And so we were like explicitly told, you have to devote some of this to providing financial support. And I'm willing to bet other schools have those things, and perhaps something co-sponsored or at least promoted by the state bar to encourage schools to find those means could be really useful as well.
And I think you raised an excellent point, Shalak, that we didn't factor into this about how many diverse students are first generation lawyers, and families are thinking like, yay, you're the one that made it and now you can help everybody else out. And so you do have now an additional layer of obligations that, plus your $1,000 payment out of your $59,000 salary, it's just a lot of compounding issues that I think are very appealing, again, to companies that are looking on how they can make an impact to the community right now. And Michael, I was going to say, when I mentor young people that are thinking about going to law school, one of the things I always tell them is, as you're trying to choose between which school you want to, go talk to the Career Center. So start at the end, right? If for what is the attrition rate look like? What kind of career placement do they have? What kind of salaries are people getting? Like, before you make a decision about what you want to pay, or start to have those leverage conversations about, could you match or beat this scholarship package you gave me? See what the end looks like, because I think those are realistic considerations. So.
Such good advice. What's your passage rate? What's your employment rate? What's your average debt on graduation? I mean,
where are people in 5 years, all of that.
You guys, great idea, by the way. Thanks for everything, Kristen and Heather. I wanted to point out that we still have to walk through the our work plan, and on my list it says it's going to take about an hour and 20 minutes to do that, and so.
So we can try to do it in 58 minutes. But if we can move to that, that would be great.
Yeah.
All right. Thank you, everyone, for your comments. We really appreciate it.
So do we need to do anything with this? Like, do we vote to add it to the work plan?
No, we can just talk about it and add it to the draft work plan as we're walking through the plan.
Okay. Thank you all. And thank you.
Thank you.
So just really quick before we go to the work plan, Gagan kindly reached out to Suzanne while we were in the meeting to ask the question about sharing the brochure. And so obviously, COF members, you're welcome to share it, post it, however you like, but we recommend that you don't comment substantively on the brochure on each other's posts to avoid any Bagley-Keene violations. So thank you. Okay, so I'm going to share my screen, and this what you'll see is a work plan in Redline that what we had done with the work plan from 2020 is reached out to all of our existing working group members and asked for their recommendations for the 2021 work plan. So based on that, I also did some reorganization because just to group kind of like things together to make it a little easier to read. And so what generally happens is COAF works on a work plan, approves it. It goes to the Board of Trustees to for the Board of Trustees to approve either in January or March of this year. And I think for 2021, we're trying to get it to the board in January. So just wanted to provide that background so everybody knows. Okay, so this is the charge of COAF, and one of the recommendations that I am making is that previously in the work plan we had creating the reciprocal liaison positions between California law and the California Lawyers Association, and then having the one liaison from the Judicial Council. So I'm suggesting that we put it up into the charge since it's not really a work plan activity. So unless anybody has any comments, we can move forward.
That sounds like a good idea.
Okay. And then, so the first item is from Goal 4, Objective H, identify means of supporting law school programs to improve retention by 2020. And so this is, the working group is Shalak and Sal, and you've recommended adding review and analyze law school survey findings, which makes sense. I recommend combining, developing a best practices guide to with this bullet point to review and identify promising programs and recommend effective programs for broad implementation. And so the goal would be to complete this resource by the end of 2021. And ongoing would be to continue to participate in the law school assembly with the Office of Admissions, and then to review data provided in the annual report and in the 509 reports. Any additional comments? Okay. And then this is objective I, and this is related to diversity and inclusion principles being institutionalized in the bar exam development. And our working group members are Heather and Sal. And these were your recommendations. And my recommendation is just that we clarify some of the recommendations. Heather and Sal recommending that specific terms, rules, terms, and or language to a state bar rule to codify diversity and inclusion principles in bar exam development, including how bar exam prep network teaches or tutors it or to examinees. So I wanted to know more about what the thought was behind this, because I just want to make sure we understand what it means.
I think that was, okay.
Was that yours, Heather? I can't remember.
No,
I think that was.
I think it's you.
Okay, that was mine. If that was mine, let me see. This was a while ago. Let's see, get the old brain working. If to the extent we're trying to figure out the themes or introduce these themes which are important of diversity and inclusion in the state bar, principles in the bar exam, then if it's going to be in the bar exam, then the way people are preparing for it needs to change as well, because it'd be discombobulated if we put it into the bar exam, but yet the people that are teaching it don't understand how the themes have changed or how they're being made better. So that's the idea there, is we've got to get the network of bar examiner, that universe of bar exam tutors or services to also understand how the bar exam itself is changing and in what way, so they have an understanding or create lesson plans around how to teach that to students that are to the graduates that are taking it.
Would it be fair to say including outreach to bar exam preparation network? Because I don't know if COAF or the state bar would be able to influence how they teach or tutor.
Well, yeah, I agree with you. I think that's great. Maybe we could say including outreach and alignment with bar exam preparation network, because I know that the state bar can't influence how they teach, but it would behoove them to teach it correctly if they want to have any success, right? So if they have I think alignment might bring them more of a sense of, let's be together on this, with the state bar and what we're teaching them. So that might be a little bit more of a pointed word for them to understand what we're trying to do here. So it'd be including outreach and alignment with outreach to and alignment with the bar exam. Yeah, I think that would work.
So just because as staff, I maybe asked this, what do we mean by alignment?
I mean, if the advocacy is there, is one thing is to outreach and to say, hey, we're doing this, and they say that's great, thank you very much. We appreciate the information. The alignment is more like if they have questions or they have some issues with the particular concepts or themes that are going to now be introduced or principles introduced in the bar exam, then that would be good for us to know, because they're working with the grads more directly than anyone, and have that present firsthand first person knowledge of what's going on. So the alignment might be that if there's something that we are suggesting the bar exam go in one direction and they're saying, well, have you thought about this or have you thought about that, then we might be able to make that adjustment accordingly.
So alignment and approach.
I was going to recommend, instead of the word alignment, can we use the word feedback?
That should work. Yeah, I think that would work.
Because so if we are going to codify D&I principles in the bar exam development, this would typically be a state bar rule. And so it would be drafting a state bar rule and kind of going through that entire process to get it approved, which would include a public comment period.
Right. Yeah, I guess feedback is good, but I mean, you're talking to a bunch of lawyers. That implies now, when is feedback? How long does feedback take? But I think for purposes of this, I think that works. At least to get that understanding that we're talking to the people that are actually going to teach this or tutor this to this.
And just in terms of like the length of time for feedback, if we do get to the point where we are putting forth the state bar rule, it would have to go out for a public comment, and our public comment periods are typically 60 days. And so in that time period, it would be us where, COAF members and others reaching out to these stakeholders to get their feedback.
Okay.
So that's typically what would happen.
Yeah, that'll work. Elizabeth,
okay.
Yeah.
And I'm sorry, Heather, did you have another comment?
On the third bullet point when you get there.
Okay. So I think the second bullet point is straightforward. And so the third bullet point.
I'd want to add, let's see, broadening education and outreach to the legal community, including consideration of broadening the geographic requirements for graders and pretesters, as well as targeted outreach too. So we're still in those conversations about asking them to consider broadening it beyond the current restrictions. So I want to make sure that stays front of mind.
So where do you want to add those words?
After including, before targeted, including consideration of broadening the geographic restrictions.
I think they've already done that.
Did they? We had discussions before we went into quarantine, and I think the result of the quarantine and how we've had to pivot has given us some, given them more consideration of our request, but I haven't heard an answer back.
I thought they had, but we will keep this in.
Okay.
Yeah. And then a joint task force with the Office of Admissions. Are you asking for, what are you asking for? Like COAF members and admissions staff to work together on something, or is it existing kind of what we already have existing?
I think it's what we already have existing, but Sal, did you think something differently with that?
Yeah, I think this was, let's see, Office of Admissions and develop key performance factors. Yeah, I think, no, I think this works in terms of, yeah, for COAF to work with Office of Admissions. I think the idea I had behind this comment, and it was a while ago, was the whole notion of trying to work with the schools as they welcome students into law schools, have that sort of understanding with them on what, you know, what might be in the future of the state bar.
So is it different from our existing working group and how we work with the Office of Admissions, or do you want something separate?
No, I guess that would work. If we have the KPIs with the current group, then we're probably okay.
Okay, so then can I just revert it back to what was the language before?
Yeah, I think that'd be all right. If Heather's okay with it, I'm okay with it.
Yeah, that's fine.
Okay. Okay.
I think we have to add an and though, after what we just added about the geographic restrictions, broadening geographic restrictions and targeted outreach to affinity bar associations. Yeah.
Okay. And then for this last bullet point, I think adding annual is great, but I don't think we can add annual as a condition of employment.
Why?
That I mean, I can ask, but I feel like it's maybe overreaching on COAF's part to request that.
But we're recommending it.
Yeah.
It
Yeah,
says
I agree.
recommend that the state bar require that.
Yeah, I mean,
recommend that they require it as a
I agree.
certification.
I mean, a lot of things happen in a year. So if we do this, you know, if you do this
And
every 2 years,
and I
every
don't
3 years,
disagree that the requirement should be an annual employment, in an annual training. I just think that the Board of Trustees may you know, have a question mark about as a condition of employment. We probably will have to go through OGC to ask them about whether we can, you know, like it. I think it having perhaps a softer approach may be more effective here.
We couldn't make it like one of those, I'm sorry to butt in, I'm not my working group, but I literally just got the email from the school, like, reminder, you have to do your sexual harassment training and whatever. Like, couldn't it be like one of those, like you have to do your 3 or
we have those
whatever?
requirements as well. I just think if it's a softer approach from COAF may be more effective.
I tend to agree with that, Elizabeth. Maybe we could just put recommend and leave out the as a condition of employment, because I mean we'll get the message across just through the recommendation alone. You know, the as condition of employment sounds punitive, and I don't really think COAF as a sub entity is in the position to, I guess, engage in any type of punitive measures against state bar staff.
I don't think it was meant to be punitive. It was actually meant to incentivize. If you have the ability to do the training at any time at your convenience versus before you start the process as a grader, I think it may just slide by. People are busy, they're focused on being a grader and they just want to get started. But if you know you can't get started until you've completed that training, I think you're just incentivized to knock it out faster. So it wasn't meant to be punitive. It was meant to, again, just kind of be a checkbox that you need to cross before you can get started, a certification of sorts.
Yeah, I agree.
I mean, by saying it's a requirement, you know, and I'm a rule follower, but you know, if I see it's a requirement, I'm going to think I'm going to need to do this before I do anything. So I again think a softer approach would be better.
I mean, but see, you've actually just underscored the point of it, is that if it's a condition of employment, you are going to do the very thing that would help solidify the chances of the COAF principle to actually take effect. So you're right. And so again, you know, to echo what Heather said, it's not, you know, assuming positive intent here, it's, you know, however you want to word it. I mean, the thing is that if you don't add a little teeth to this, I mean, you can't really assure that this is actually going to be successful. Because if people say like, well, it's one of those trainings, I can skip it this year, I'll skip it next year, and I'll never get to it. So whatever kind of other things we've done won't be really enforced because of this one thing. So maybe we can say, require as part of the job description or something like that of every person, that they are required to take this bias training as frequently as possible, no less than a year, something like that. So I mean, we can wordsmith this, but the idea here is to make it part and parcel of somebody's employment experience, that they do have to take this training on an annual basis.
If it's softer to say prior to the initiation of grading or something instead of condition of employment, which I feel like is sticking in people's jaws as like a term of art, but I think it does need to be before you get started, or it moots the point. Like they need to have this. And I also I don't think it should be viewed as a burden. These are all things that everybody needs to be doing, like to be better citizens in the world. So it shouldn't be like, I have to do the implicit bias training. It should be like, great, if I want to take on this responsibility of holding, power into people passing the bar exam, the least I can do is take implicit bias training.
Okay, so I like prior to engaging in
your job. You know what?
The other point I wanted to make is that, COAF requested the implicit bias training in March at the February meeting, and the Office of Admissions implemented it before review of the February bar exam in March. And so the Office of Admissions was really responsive. And I just feel like saying as a condition of employment feels too hard, and as Ryan was saying, punitive, and is not kind of like the relationship we want to have. And so that's why I'm pressing on it.
I mean,
not because I think it's important, and not because the Office of Admissions doesn't think it's important, but I'm
not married to this idea. I mean, I think that Heather and I have made our point that, you do want to tighten this whole perspective of this is not going to work unless we have everything working in unison. So, but if you want to say something like, recommend the state bar require implicit training by all staff no less than once a year, or no less than, every 18 months, something like that.
Yeah,
where
we
it's a
have
little
annual
softer.
here. We put in annual.
Yeah, that's fine.
That division.
No less than no less than once a year or something like that. Yeah.
But if you want to take out as a condition of employment and add in prior to engaging in the grading and monitoring process, if you feel like that,
Yes.
Because for the March bar, I know they offered it. Did they mandate it?
I think they did, but I don't have that information.
Yeah, see, that would be interesting now that Heather says that. It's like, if you look at the stats, I wonder how many people actually took it before they started grading. And see, and that's the thing, is that, if we don't try to keep the front door, nice and tight, then everything's going to go out the back. So, but again, I think this works the way that, Heather's proposed here. So I think that works. Yeah.
Okay, great. Thank you. Are we good? Oh, Shalak, you have a comment?
Well, I just
Sorry, we didn't mean for that to be a controversial item.
I had a clarification question that you might get, Elizabeth. When we say annual prior to engaging in proctoring and grading, is that for both February and July? Say like it's for 2021. If someone does it in January 2021 and they do February and July, does that cover them for both exams? I just can foresee someone asking that question and being able to clarify that.
I think it's per calendar year. So I think if you do it in, before the February bar, you don't have to do it again before the July bar.
Yes, that
the
makes
same
sense.
calendar year.
But if that's the goal, I think for it to just make sense, I think it would be to say either to each calendar year and also before, like, you do your, the wordsmithing, your first review at proctoring, right? So both every 12 months for everyone and before you begin any of the substantive work, but just not as a condition of employment. I think it was that language that tripped us up a little. But I think the goal you're trying to accomplish can be accomplished, as long as it's before doing, the work.
Right. Yeah. I think that works. Yeah.
Oops. Okay. So are we okay here?
Yes.
Yeah.
Okay. Okay. So the next one is related to the California Bar Exam Strategies and Stories program, formerly called the Productive Mindset Intervention. And as many of you know, this is a intervention that is available to bar takers, where you can participate in a program where you hear from other previous bar takers, and I think predominantly bar takers of color, who talk about how they manage the stress and were able to be successful. And really the study's really looking at stereotype, threat, and imposter syndrome. And so we've had some preliminary, very positive results related to this study. And so it was conducted for the July 18, July 19, and October 20 exams. And we'll be also conducting it for the February 21 exam. And so once our researchers have had time to analyze the data and produce some findings, we'll have them, I anticipate by May, but I have to check with our Office of Admissions. So we may have them come a little later next year to just provide a presentation on the report, and COAF can make some, provide feedback or recommendations at that time.
My one question is kind of less about this specific item, but more about integrating our new COAF members into working groups. Are we going to be doing that now?
Well, I have reached out to, I think, all of them regarding working groups. And so I think we can plug them in offline so that we're not spending meeting time on it, if that's okay.
Sounds good. Yeah.
And, even though there are working groups attached to some of these recommendations on the work plan, I do encourage all COAF members to chime in if they are moved to. Okay. So then Objective L is kind of the largest chunk of our plan. So it's related to analyzing available data to identify particular obstacles to diverse attorneys' entry into retention and advancement in the profession. And so we have this one very general work plan activity, make recommendations for actions the bar can take to address identified findings. So, my recommendation would be to either, expand this to be more specific, or delete it, and maybe focus just on this bullet point, which was identify D&I programs at firms, in-house, nonprofits, and government agencies, and to develop and disseminate best practices. Do people have thoughts on that?
That works. Yeah.
Okay.
That makes sense.
Okay, so then can I delete this? Or do you want to keep it?
I think you can delete it. It's so general that
delete it.
Yeah,
Okay.
then it doesn't really add.
Okay, great. And then plan and participate in diversity summits. And I deleted what we had last year by sector because just because of the way the year has shook out, with us only completing 2 of the sectors in 2020. 2021 we'll complete government, but then we may want to think about how we want to move forward with diversity summits in the future. So I made it a little bit more general, just to give a little more flexibility.
Just the thought came to my mind about, the state bar and COAF kind of bringing together and bringing in industry experts on D&I, and essentially creating like a manual for different, like law firms and public sector organizations, to just refer to that manual on all the best practices specific to the organization, and having positive D&I efforts. And it's just an idea. I was wondering if we can do that, if that's already something that we're going to do, but just a specific manual that they can refer to, that's like their Bible on diversity, equity, and inclusion.
Who would be the audience? I'm sorry, I missed that beginning.
It would be the folks who are in charge at, law firms like the
Okay.
equity partners, or maybe if there's an executive director of a public agency or a public sector nonprofit or something, and they want to really do good in that space, but they don't really know what to do. They just kind of know they want to. They could pull this manual, and it will give them clear instructions on where they need to focus their efforts and resources.
Would this, the second bullet point kind of capture that?
I think it almost gets there, but not all the way, because if we're just identifying the programs, that's different than saying, here is your Bible, right? And
So how about we have develop and disseminate best practices? Is that closer? Do you want to add something to that piece?
How about develop, create, and disseminate best practices playbook, Ryan?
Yeah, that sounds better.
Develop, create, and disseminate best practices playbook. And that's another project, I guess, for.
Can we
us.
say guide? Because
Yeah.
I think we use guide in somewhere else
I just wanted to say that I don't think that private firms are really going to use this. So I worry that there'll be a lot of energy spent on this that is wasted and could be better allocated to some of these other projects. Because typically the first thing that private firms do is they hire somebody dedicated to diversity and inclusion. And then, for example, I'm a member of the Association of Law Firm Diversity Professionals. We have a listserv, we share ideas, we do stuff. So nobody in that organization is going to bother reading this. So I think we just leave it at best practices, and I think that's great. And that'll be useful, but then it sort of reserves resources that are better spent, I think, on other things. Just my 2 cents.
Having come from Big Law, I'd be inclined to agree, but I would say I think it's maybe worth, outside of, I know we have limited time right now, Elizabeth and I have already started to do some brainstorming around, are there other ways the state bar could encourage different entities, including law firms, to engage in some best practices we would recommend? And is there a way we can spotlight them or recognize them when they, make certain efforts or achieve certain goalposts in terms of diversity efforts? And so, I think that's a bigger conversation, how we can possibly be motivating in this space. But
yeah, well, here's the issue though. Not every firm is a big law firm. They don't have resources to hire an expert on D&I. And I know my firm, which is a mid-sized firm, 8 offices, over 150 lawyers. We don't have a person who's specifically hired for this, but they are definitely interested in it. And like the equity partners are calling me and asking me what I think, and I'm basically kind of relating information that I'm getting from COAF and stuff that, remember Dr. Erin Reeves, that she said during the diversity summit about 1.5 years ago, and they're eating it up, and it's really good information for them. And so it's kind of like there's a lack of knowledge for folks that maybe, for firms or organizations that don't hire a resident expert, but still want to do well in that space. They need to have a resource available. And even if there are experts that you can pay and they'll come in and give you a lesson, they're not all created equal either. You may not get somebody who's going to give you good actionable information, but we'll certainly take your money and ask for a good review on their website, something like that.
Yeah. If Andrea and Elizabeth, if you need any help on developing whatever you're developing, count me in on that.
So, I think, can we say, instead of guide or playbook, can we say resources? And I feel like that then will be, if we do decide to develop a guide or a playbook, we could, but it doesn't tie us to, because I think we are going to have to look more closely at this specific item, because a big law firm's needs are going to be very different from a small firm or solo, and in-house departments, nonprofits, and government agencies as well. So would you feel comfortable with changing guide or playbook to resources?
I like resources.
Great. Thank you. And then these two, they're redline only because they were further down in this list, and I pulled them up just to group them with these other items. And they were in the 2020 plan. So provide input and feedback on the efforts to ensure an effective and fair attorney discipline system, and then provide input and feedback on recruitment and retention, including LRAP. So I think for the attorney discipline item, I think, you know, what we've been doing has been pretty effective. We have a working group that has, you know, provided feedback to ORIA as they're, you know, working on their research and recommendations. And then ORIA and DAG come and speak with us and provide updates. So I don't think there's anything we need to add at this time, unless other people feel otherwise. And then for recruitment and retention, I think we can definitely add including loan forgiveness.
Yeah, that sounds right.
And I don't know if you want to put in, you know, partnering with, you know, the Legal Services Trust Fund Commission or the Access Commission, or if you just want to have kind of a general item here, or if you want to provide have more specifics.
I say leave it general. That way
we have flexibility.
We can wreak havoc in areas beyond the state bar.
I didn't hear that.
I don't know what you said.
Okay. Any other anything else on this bullet point? Okay. And these two items, even though they're redlined, were just pulled up from other parts of the work plan to put it with this other bullet point about inviting experts to provide presentations to COAF. And so this is, you know, support presentations to high school and other to underrepresented high school and other students. And then kind of a big ticket item for the working group is to convene a one-day pipeline summit in 2021. And so to gather, you know, stakeholders who are working in the pipeline space to kind of get a status report and kind of communicate with one another in a more official way. So this item is the video item. And so as we reported earlier, the video with David Kelly, I think is really great. And I actually saw an email come through that I had the public link, so I should be able to send it to you after the meeting. I wanted to know how we wanted to update this. You know, it sounds like we want to continue to do at least a couple more videos, or at least one more video, because we have Linda Bagley in queue and ready to represent. Yeah, how do we want to edit this one?
Do we want to change it from explore the feasibility, because we already know?
Yeah, so it's maybe partner.
Yeah, continuation of partnering or something like that, since we've done the first one. Yeah, I think, do we need to say anything?
I think that sounds good. That was, yeah, thank you. Thank you, Heather. Okay. And then this one is regarding the liaisons. So I'm recommending that we just move it to delete it and move it to the charge, since it's not like an activity we need to actively do. Okay.
Yeah, that's fine.
And then this one is the brochure. I'm recommending we delete it because we completed it.
Yes.
Yep.
Yay.
Can you put a gold star next to it also?
Yeah.
I actually found a sheet of Gold Star stickers. I think I might mail you some.
Okay.
Or should we move it? Or should we?
I want some cookies, Kristen.
Should we update it to say distribute? Because we've updated it already, but now we still have to get it out to folks.
There you go. Disseminate.
Disseminate.
And publicize or something.
Disseminate, publicize.
That word, I don't know.
TikTok. I'm kidding. I just heard that come up earlier.
I don't know, Heather.
I don't know how to TikTok.
I don't even know what that is.
No, yeah, just disseminate, distribute the state bars. Do you want to be no? What is it? It's
it is
a lawyer, make a difference. Be a
You
lawyer,
came
make
up
a
with
difference. I know. Be a lawyer, make a difference. There you go, brochure. Yeah.
It's your tagline.
And do we need to say something regarding the effort to do it on social media or via social media in addition to the hand distribution? How about just distribute and publicize via social media outlets? And publish via social media outlets, something like that. Publish via social media outlets. Yeah, that might work.
Can you say social media and other outlets just to make it a little bit more general to allow for the presentation?
Yeah, you're right. That's true.
We might use them at college fairs or, you know.
Yep.
Okay, so then I'm going to delete this last part then. Is that okay?
Mm-hmm. I think that'd be fine.
Okay, great. And then,
wait, quick question. Do we need to maintain, and I don't know in the context of how this is going to be presented, but that last part that says to high school, community college, and college students, I think the mandate involved trying to reach out to high school and is actually as young as elementary school children. Do we need to put that anywhere here, that we have the target being, that the remit of this particular action item here is to get to those folks in, from elementary school all the way through the college level?
so the Board of Trustees in its strategic plan determined that pipeline into the profession for the state bar would really be a focus in law school and law school forward. And so, earlier this year, Judge Brenda went to the board to ask if we could do kind of these very limited specific things related to outreach, reaching back a little bit to high school. And so the board was agreeable. So I think we need to honor that it was very specific what the ask was, and that, now that we've completed it, we can take the next step, but I don't think the board wants us veering too far from what they've already determined to be the state bar's priorities.
Yeah, no, I didn't mean to imply that. Sorry, I meant to say just that do we need to in this particular bullet item reflect a specific target audience, or does it matter here?
Well, I mean, the brochures and the online version, it's I think it's clear who the audience is.
Yeah. Okay. All right. Works.
Okay.
Yeah.
Okay. Great. And then this, this is just something that got moved up. So the next item is Objective M, which is related to the elimination of bias rule and revising that rule and developing the curriculum. So I'm recommending deleting, putting out the rules for public comment and, working on the rules because we've completed that. The rules have been approved. But we are keeping in the work on the online implicit bias module, which we anticipate completing by March. So I think that's pretty straightforward. Okay, and then the next item is related to the annual diversity report card. And so I think many of you know that the state bar is working on a survey to all attorneys to gather information on the impact of the pandemic on attorneys, and specifically on whether it impacts diverse attorneys. Because, you know, we saw in 2008 with the Great Recession that diversity and inclusion efforts were really, that there was an impact there. And so we've added reviewing the findings from the attorney survey on the pandemic and make any recommendations. Does anybody have anything to add on this?
I think that's sufficiently broad to cover anything we want to do.
Okay. The other thing that I think we should also add is one of the goals with the report card is to look at the calls to action and help work on making them more sector specific. And so if you're agreeable, I'd like to add a bullet point on that. I can wordsmith that to be more clear or articulate when we're done. But if that's something that we can add, that would be great.
Elizabeth?
Yes.
I don't know that I know that the first report card came out last year, and I'm assuming it's sort of like an ongoing part of the call and annually thereafter is that we'll publish it again in 2021 and so on. I don't know whether that's something that needs to go on there or whether it's just assumed in the objective itself.
Yeah, it's ongoing. It's kind of out of COAF's hands at this point and how the report card will be published because for the one that we published in July this year was a PDF static report. Moving forward, I think I've shared with some of you, we are hoping to have more of a dashboard that's available on our website that's a little more dynamic. So, for example, if somebody wanted to go in and look at data related to diversity and inclusion efforts in a law firm with 500 attorneys, they could find that information. And so that will be ongoing, and that's kind of the staff's vision to get that information and data up there and available. And I think it would just be maybe tweaks to the calls to action that would be the thing that would be updated annually. Okay. Great. And then the last objective is related to the Judicial Council, and this is very specific to update their Judicial Diversity Toolkit. But we are available, as I mentioned earlier, to the council to provide assistance and support when requested. And so I think we can keep the first, second, and fourth bullets, but delete the third because we did complete that. And then we also, this is the liaison position that I'm recommending we put up to the charge. And then last year we actually had a little bullet point for our trainings, but I think we can, we've already done our trainings for this group of cohort of COAF members, so I think we can delete that. And actually then I think we are complete unless people have additional items they would like to add.
Can we're going to put the loan repayment forgiveness thing under the retention, or should it be its own bullet under whatever? I know you wrote a note to yourself on the side that said, do we want to create a
Sorry, I'm trying to find it again.
It's right there.
Okay.
Do we need an additional working group?
Oh yeah, so in terms of working groups, this objective is really big, so we have a bunch of working groups, and so we will create a working group for it. And my note here is really, what your request was, and to remind myself that the Trust Fund Commission, the Access Commission are interested.
Okay.
So are there any further comments or additions that anyone would like to make?
I did see that for training purposes that there was a line item about trying to do something other than just a 1-hour training, specifically anti-racist training. And I didn't think it was appropriate to raise it before, but I'm sure, as you all know, there's been reports and studies that doing 1-hour trainings has very little impact, unfortunately, on behavior, although it's better than nothing and we have to do it. So I do think that, maybe that's already subsumed by that bullet point, but I think it's worth considering. For example, the ABA had a 21-day 21-day racial equity habit building challenge that a lot of people did. A lot of us have been doing some soul searching about what we can do that is more personal and has more follow-up and isn't just kind of a talking head. So I do think that, should be an important picture of this, or something to at least thoughtfully think about. Maybe it's captured there for the future already with what you have, but just wanted to kind of throw that out there.
Mm-hmm. I know this item, Judge Esther wanted us to add this because in the public comment for the rules revision, these were some of the comments that, we did receive a lot of comments that, training doesn't really impact people's implicit bias. And yes, there needs to be definitely more work for a person, especially personal work. But I think it's one step a person can take. And so, I think an ongoing discussion on that could be in that bullet point, unless you want to add something more specific.
No, I just want to make sure it's kind of on the table to think about. I just think it's an important area. So I wouldn't want the bar to be ridiculed for, only doing a 1-hour training and not thinking about other things.
Okay. So. That's important. Okay.
I guess the only other comment I had, and I'm sorry, we're almost at 4 o'clock, was I also attended the American Bar Foundation talk by Justice Goodwin Liu that I know Judge Rossi attended, and it sounds like you did, Elizabeth, maybe other people did. And I was really surprised by some of his findings that the number of Asian Americans going to law school has declined precipitously. And so that is going to lead to, further issues down the road in terms of Asian American diversity in the legal profession and the judiciary and everything else. The other thing I was going to mention is there was a study this summer by the ABA about women of color, specifically left out and left behind. Excellent study. It's something that I've been spending a lot of time trying to think about. I just want to make sure that we're all kind of thinking through some of those issues, which really permeate a lot of the work that we're doing here, but it may warrant some sort of special reach out to Asian Americans, for example, to combat what, Justice Liu was talking about in particular, among other things. So again, sorry to raise it at this juncture, but I didn't think there was a good time before, and we can't have offline conversations. So here we go.
Yeah. And one of the things that Kristen and I have talked about is inviting Justice Liu to a future COAF meeting to share his paper and to talk more about, what can COAF, what can the state bar do, maybe help facilitate a discussion with the group. And I think that would be totally appropriate and wouldn't need to be in our work plan.
Right.
And so, I do think what the issues you raise about, outreach to particular groups and kind of being cognizant of like the kind of the literature that's coming out related to D&I and kind of the studies that are ongoing, I think that we can still move forward on things because our work plan is, I think, sufficiently broad enough, but specific that we do have deliverables, but we also can be more nimble when there are new findings.
Sounds good. I just wanted to raise it just because it's something I've been giving a lot of thought to.
Yeah, no, I really appreciate that. Okay, if there aren't any more questions or issues that people would like to add to the work plan, I would like to ask that you approve the work plan and recommend that we present it to the board.
All right, now, as chair, I can't move, can I? Or somebody else has to.
I so move.
I'll second.
Okay, so Sarah, was that you?
Yes.
Okay, sorry, I couldn't see, I can't see people right now. Okay, and Sal seconded?
Why don't you put Heather in there, because she had that, I think, before me. So Sarah and Heather.
Sorry, I had to pull up my my
No,
roll
it's
call
okay.
sheet, so I can't see people. Okay, Heather seconded. Okay.
Yep.
So I'll take the roll call now. Judge Esther, Ryan,
Aye.
Heather,
Aye.
Novella,
Aye.
Sarah,
Yes.
Michael,
Yes.
Shalak,
Yes.
Kristen,
Aye.
Stephanie,
Yes.
Sal.
Aye.
Great. Motion carries.
All right.
Okay, thank you. I'm sorry we blew through that so quickly, but we have 5 minutes left now. I really do appreciate all your thoughtfulness, and I'm actually really now excited for what we're going to do in the next year together.
All right. Thanks, everybody. This is great. I'm looking forward to the next, to the work we're going to do in this next term. Thanks.
So that's the last thing on our agenda, unless anybody else has any further comments they'd like to make with our 4 minutes remaining.
Just happy holidays to everybody.
Stay safe.
Have a safe
Yes,
one.
happy holidays. Stay safe.
Stay safe as we head into another quasi shutdown, at least here in the Philly area. Just came out today. So
Yeah, I just got an email.
All right. So as acting chair, I guess I can do the honors of saying we are officially adjourned.
Thank you, Ryan.
Thank you, Ryan.
Thanks,
Good job,
Ryan.
Ryan.
Thank you.
Thank
Happy holidays.
Bye, everybody.
Okay,